Hello students, welcome to Recital Plus, your syllabus aligned current affairs session. My name is Harshit Johari, and in today's session we will not be just reading news but decode it for you as well. More importantly, we will be helping you with the PYQs and the practice questions for your better understanding. In this way, you will be able to revise your current affairs in the most efficient and time-bound manner. The main important themes that we'll be discussing up today is social issues, polity and governance, international relations, science and technology, and culture. Let's start with the social issues, and the first thing is that Supreme Court reconsider gender stereotype handbook. What is this handbook? Is basically its approach to gender sensitivity, the moving beyond the 2023 handbook. Supreme Court has recently decided to move beyond the 2023 handbook that was provided by the former CJI D.Y. Chandrachud. The current CJI Suryakant described the handbook as overly academic and stressed the need for more practical ground level and judicial trainings. Okay, so what this shift to institutional training from the handbook, how it would be happen? The bench observed that handbook has relied on more forensic meaning, technical and clinical interpretations which may not be in sync with the survivors' lived realities or common social understandings of India. They have promoted that it is overly theoretical and disconnected from the India's ground realities as well. So the court provided that instead of relying on the advisory text, the bench emphasized that there's a need for structured institutional reforms. How these reforms would be? First, the court directed the National Judicial Academy Bhopal to constitute a committee of domain experts, academicians, and the lawyers who draft practical training guidelines. These guidelines, when finalized, would become the part of NJA's curriculum for High Court judges. Once finalized, judges will undergo in a batch-wise training focused on handling sexual assault cases with sensitivity and legal clarity. Okay, what was there in the 2023 Gender Stereotype Handbook? First, it was released in August 2023. Handbook on combating gender stereotypes aimed to eliminate patriarchal languages and biased reasoning from the judicial decisions. Then CJI D.Y. Chandrachud stressed that language shapes justice, warning that stereotypes distort the law's application to the women. Hence, he came up with a handbook which suggested some of the reforms in the courtroom language. For example, adulteress was replaced by the women who has engaged in a sexual relationship outside marriage. Eve teasing is street sexual harassment. Okay, child prostitute was replaced by the child who has been trafficked. So that is how they were trying to curtail on the patriarchal norms in the judicial orders. Apart from that, it also challenges judicial reasoning patterns. Beyond vocabulary, the handbook sought to dismantle stereotypes in the judicial thinking, particularly in the sexual offences cases. For example, inherent characteristics. It rejected assumptions such as that all women want children. Women are overly emotional. Young women cannot take major decisions. The handbook clarified that gender does not determine rationality or autonomy. It also challenged the gender roles. For example, working women are negligent mothers. Women must be submissive. These things were rejected in the given handbook. Approach to the sexual violence cases. The handbook addressed evidently misconceptions in the rape trials. For example, clothing, alcohol consumption, lifestyle do not imply consent. Lack of physical resistance does not mean equal consent. Absence of injuries does not invalidate testimony. So these were the things that were mentioned in the handbook. Now Supreme Court is going for more structured judicial training and academic for this purpose. If we see the judicial precedents which were cited, though Supreme Court in the state of Punjab versus Gurmeet Singh case stated that survivor testimony is inherently credible. State of Jharkhand versus Shalendra Kumar Rai case banned the two-finger case in the rape cases. Okay, so before that, let's see the PYQs. Government supreme law officers and legal firms are recognized as advocates, but corporate lawyers are patent attorneys and excluded from recognition as advocates. So basically, the working procedure of the courts has been asked in the UPSC examination. On that basis, we have a prelims probable question for you. Consider the following statements regarding gender stereotype handbook. It was originally issued by the Supreme Court to guide judicial language. This is a correct statement. It is legally binding on all the courts in India. This is not legally binding. It aims to eliminate patriarchal biases in the judgment. This is a correct statement. The answer would be 1 and 3 only. Now, let's see the mains question, because this topic is more important for your mains point of view. Discuss the significance of eliminating gender stereotypes in judicial discourse. How can constitutional reforms strengthen gender-sensitive justice delivery system in India? Apart from constitutional reforms, for example, gender of justice, you can also value add based on this article. For example, significance of eliminating gender stereotype in judicial discourses. Promote fairness and neutrality. For example, we have seen here the reforming courtroom languages. Challenging judicial reasoning patterns. Apart from that, inherent characteristics that were rejected. Also, the gender role stereotypes were broken down with these things. However, practical challenges inside the courtroom is the reform that is required in the language and also evidentiary misconceptions. Okay, so it is good. The Supreme Court of India has come up with a curriculum update and also promote judicial training. That's how we can strengthen gender-sensitive justice delivery in India. Moving to the next is annual statistics reports on death penalties. So death penalties, annual statistics reports based on 2016 to 2025 data and recently by the Times Square Clinic. The Square Circle Clinic, formerly known as Project 39A, you please remember this fact for the prelims examination, is a criminal justice research and legal aid program that originated in the National Law University, Delhi. However, it is now based in the Nalsar University of Hyderabad. About death penalty and the reports, let's see the data. The report marks the 10 years of nationwide empirical tracking of the death penalty in India, analyzing sentencing, confirmations, commutations, acquittals, mercy petition, and procedural compliance along session courts, high courts, and the Supreme Court. What is more important is that it goes beyond the moral debate whether we should continue with the death penalties or not. It maps systematic trends and failures in the administration of the capital punishment. What are the key highlights and the concern raised? First is the scale of death penalty use in lower courts in India. 1,310 death sentences on 1,279 individuals by the session courts between this time period across 822 cases only. In 2025 alone, trial courts sentenced 128 persons in 94 cases, showing that lower court imposed death penalties very frequently even today. Record high death row population. As of December 2025, if you see, 574 persons were on the death row, out of which there were 550 men and 24 women. This is the highest death row population since 2016. Even that means the data is showing an increasing trend, even though confirmations by the higher courts have steadily decreased. The rise reflects slow appellate processes, frequent remands, and delayed finality rather than increased judicial endorsement of the death penalty. So what is happening? Lower courts are giving more death sentences which are declined by the High Court. However, the number of people who are on the death row is increased. It may be because of the justice delayed. Apart from that, appellate court rarely upholds death sentences. Acquittals consistently outnumber the confirmation by nearly 4 times in High Court and twice in the Supreme Court. High Court considered 842 out of 1,310 cases, and the confirmation proceeds but upheld only 70, that is 8.31% only. And it set aside or modified 90% of the death statement they considered in 2025 alone. Supreme Court decided 153 death sentences, cases of which only 19 were confirmed. No death sentence has been confirmed since 2023. In 2025, court acquitted 10 death row prisons, the highest number in a decade. Apart from that, there's a high incidence of wrongful convictions also. Over the decade, 364 people were wrongly convicted and later acquitted. That is also a part of the debate, that if the person were given the death penalty, how we can restore. Crisis in sentencing processes. 95% of the death sentences were imposed without compliant sentences hearing, or either they happened immediately, so that person is not well prepared again. Women and the death penalty. 10 women were sentenced to death in 2025, which is highest figure since 2016. Nature of the offences: murder simpliciter accounted for the largest share of the death sentences, followed by the murder with sexual offences, non-homicidal child rape, and dacoity with murder. This indicates that the death penalty may not be using the rarest of the rare doctrine, and it is not confined to exceptional categories like that of terrorism. What is happening? They are shift towards life imprisonment without remission. That is how courts are shifting. They are changing the death sentences to the life imprisonment without remission. Mercy petitions. 19 mercy petitions were rejected and 5 were accepted in the last decade. Mercy relief often came after 15 plus years on the death row, raising humanitarian and constitutional concern, because you can understand the situation of the person who is on the death row for like next 15 years. Reasons for lower death penalty rate confirmation. First is as trial court skepticism. Acquittal rates exceed confirmation rates in high courts 4 times, in the Supreme Court at least 2 times. Defective investigation, unfair trials, non-compliance with the sentencing law, that was Manoj versus State of Madhya Pradesh, mitigating factors often ignored despite the guidelines were given in this particular case. Constitutional elevation of the sentencing safeguards. In Vasanta Sampath Dupare versus Union of India case, compliant sentencing hearing were held integral to Article 14 and 21. rarest of the rare doctrine that was given by the Supreme Court in Bachchan Singh versus State of Punjab case. That means the death penalty should be awarded only and only in the exceptional cases. These things are not being followed properly, especially by the lower courts in India. That is why there's high number of the death penalties. However, the confirmation is really low. What needs to be done? First, strict enforcement of the sentencing guidelines, professionalized investigation and prosecutions, early judicial scrutiny, uniformity in the judgment, especially under POCSO across states. Revisit the death penalty framework and develop a compensation framework for wrongful and death row incarceration. Okay, so with this, please understand, let's have a prelims question with reference to the death penalty in India annual stats report. Consider the following statements. The report has been released by the Square Circle Clinic based in Nalsar University of Law. That is correct. Appellate courts in India frequently uphold death statements awarded by the lower courts. This is an incorrect statement because I have seen there's a consistent decline in the confirmation part. The death row population in India has grown a declining trend in recent years. This is an also incorrect statement because we see this as the highest death row since 2016. So this is also an incorrect statement. Answer would be 1 only. Now let's see our mains question again. The administration of the death penalty in India reflects systematic inconsistencies rather than principled justice. Critically examine the reference with the recent data and judicial trends. What do we need to understand is that you have to maintain with that what is the issues, how these references to recent data, how data is coming up with respect to the death penalties, and what is the judicial trends. Are they accepting it? Is the confirmation rate is higher or not? So you have to mention the evidences of inconsistencies. For example, there's a gap between trial court and the appellate court in confirming the death sentences. Wrongful conviction, procedural violations with respect to the delays, rising death row population. However, how government judicially is taking place is correction mechanism, appellate court's role, rejecting almost 80% of the confirmation cases, shift in punishments with respect to life imprisonment without remission, strengthening due process of law, and also, for example, judicial trends. For example, we have seen in this case, Supreme Court has given up the rarest of the rare doctrine. Okay, so you can use these terms that we have just discussed to answer this question. Now, move to the next is refurbished medical devices market in India. First is, what do you understand is that recently Department of Pharmaceuticals has informed the Rajya Sabha that Ministry of Health and Family Welfare has constituted a committee to draft a policy on the regulation of refurbished medical devices. This panel will define their scope, establish method to assess safety, performance and remaining useful life, and recommended guidelines for disposal and waste management. This is to balance the healthcare access and industry policy consideration. So first of all, you have to understand what is refurbished medical devices. So the refurbished medical devices are the previously used equipments which were restored to their original operating standards and resold at a lower value. With this, you promote accessibility and hence we can give a quality healthcare, especially in the tier 2 and tier 3 cities in India. Okay, this is also for the small hospital. This will reduce upfront capital cost. This supports decentralization of healthcare and improves access to advanced diagnostic outside major urban centers. Okay, dependence on imports. This is one of the challenges that despite growth in the domestic manufacturing sector, India remains reliant on the imports for advanced imaging and specialized devices due to technological complexities and global supply chain dominance. Refurbished equipment is commonly sourced from the countries like that of US, Germany, Japan, South Korea, etc., where hospitals upgrade system before the end of their functional life. Means for that period we can use those refurbished products. Now, what is the current government policy on refurbished medical devices? India does not have a specific regulatory pathway. This is a challenge. Refurbished medical devices are treated under Medical Devices Rules 2017. Although all medical devices were brought under phased regulation from 2017, are notified as drugs in 2020. Under the Drugs and Cosmetic Acts, no separate licensing mechanism exists to deal with these products. These are also one of the challenge. Imports governed by the waste management rules as well. The Waste Management Rules 2016 governs the import of these materials. Imports are allowed only after obtaining, there's a strict provision, first, to no objection certificate from an expert committee by the Ministry of Environment, Forest and Climate Change. Also, technical inputs from the Central Drug Standard Control Organization. Import authorization from the Director General of the Foreign Trades. Earlier bans on used critical rare were relaxed in December 2022, permitting certain high-end equipment under strict scrutiny. So let's see recent approvals and regulatory clash. In November 2025, Ministry of Environment Technical Committee approved several refurbished devices for reuse. However, in January 25, CDSCO stated that refurbished devices cannot be imported for sale due to the absence of licensing provision under the medical devices rule. That means there's a conflict in the policy which led to ambiguous state. Policy ambiguity and industry concerns. India lacks a statutory definition distinguished between used, refurbished, reconditioned or remanufactured devices. So first of all, we have to have a policy. This creates uncertainty around classification, licensing, compliance, patient safety and domestic manufacturing policy. What are the concerns for the domestic manufacturers? The Association of Indian Medical Device Industry strongly opposes easing restrictions without robust regulatory standards aligned with the global benchmark. What they are saying, players argue that refurbished devices carry risk of unclear usage history, first point, which is inconsistent performance, limited traceability and shortened lifespan. They also warn with that lot of imports, India might reduce to a destination for end-of-life equipment. However, there is a debate, industry divide versus policy debate with respect to the refurbished medical devices. You have to understand that absence of a clear pathway under the medical devices rule has created uncertainty for both industries as well as policymakers. A key tension lies between promoting domestic manufacturing under the Make in India and ensuring affordable access to the healthcare with respect to the advanced diagnostics, especially in the tier 2 and tier 3 cities. International manufacturer perspective, what they are saying. So according to the Medical Technology Association of India, representing a global manufacturer, they state that the refurbished devices throughout the world are not banned, but they are regulated. Hence, we should not go for the complete prohibition for that. It contends that the regulated imports can improve affordability, expand access, support healthcare training goals, and complement industrial initiatives such as electronics, repair, service outsourcing. That means India can become a part of service supply chain, global supply chain as well. For that, there was a prelims practice question for you. Which of the following best describe refurbished medical devices? Devices manufactured using recycled raw material, that is incorrect. Used medical devices restored to functional conditions. Okay, so in this context, this is a correct statement. Answer would be B. Now let's have the mains questions. Evaluate the potentials and challenges for the refurbished medical devices market in India. How can regulation balance affordability and patient safety? So basically, they are asking, there are two challenges. First is balance affordability and the patient safety, and how the refurbished device market can help in that regard. Okay, so first of all, you see, we have the growth potential, affordable healthcare access, reducing import dependency, and also cost-effective solutions. And India can also become a part of service of the refurbished devices, and we can add into the global supply chain. Key challenges is first is that safety and performance and the concerns, regulatory gap and industrial opposition. For example, here they say that with this, India may become a destination for end-of-life products. Okay, apart from that, how we should do? We should first of all robust certification process, which I just mentioned, that it could be imported, but there's a robust security mechanism is in place. Allow import restriction should be there. It should be based on quota, or maybe after the complete safety, we must import those things. And also we must have an accredited repair ecosystem. Hence, this would promote patient safety as well as affordability of the healthcare system in India. Okay, now another news, not a very good news, is that the Economic Survey recently flagged a worrying trend of digital addiction and screen-related mental health issues, especially among children and the adolescents. Okay, responding to these concerns, Union Budget announced steps to strengthen India's mental health framework. What are these things? First is proposal to set up a second National Institute of Mental Health and Neurosciences, NIMHANS, alongside plans to upgrade premier mental health institution in Ranchi and Tezpur. So definitely they are promoting the infrastructure. Basically, they are promoting the highly specialized hospitals. First thing. Second, what is the India's mental burden? Let's see. The country accounts for nearly 1/3 of the global cases of the suicide. Can you imagine? 1/3. And other thing is that depression, addiction, making mental health a major problem in India. Second, high suicide burden among youth. That is also a worrying trend. Data from National Crime Records Bureau and sample registration system under the Ministry of Home Affairs show that suicide is among the leading cause of the death of Indians for the age group of 15 to 29, which is your primary age group. Youth people are particularly vulnerable because academic pressure, unemployment, social stress and digital addiction. Economic cost of mental illness. If I tell you, according to the World Health Organization, India is expected to lose some around $1.03 USD trillion between 2012 to 2030. You can imagine. Due to mental health condition, because it reduced productivity, healthcare bill, and premature mortality. Large treatment gap is also highlighted in the report, which says around 70 to 92%. Can you imagine this data? 70 to 92% of the people with mental disorders do not receive proper care. Why? First is the lack of awareness. Second is the social stigma attached with the mental health treatment. Second is severe shortage of the trained mental health professionals. This is also highlighted. As per the Indian Journal of Psychiatry, India has 0.75 psychiatrists per 1 lakh people. WHO recommends at least 3. So you can imagine, low budget priority as well. Although overall health spending of India is already low, out of that, this mental health received only 1% of the total fund that has been given to health sector. However, you have the burden of 1/3, and this is the budget that were allocated to the mental health. Okay, this limited funding can constrain infrastructure, manpower, and also the outreach services. And this is one of the primary cause that around 70 to 92% people, they fail to get the treatment. Now, what the government has taken, the steps they have taken is that they have expanding access beyond hospitals with respect to the integration with the mental health into the primary healthcare under Ayushman Bharat. What they are doing is that mental health will now be the part of comprehensive health system care packages delivered through Ayushman Arogya Mandirs. Over 1.73 lakh sub-health centers and primary health centers have been upgraded, where they can give you the mental health related services as well. Okay, strengthening specialist capacity as well. Over 20 center of excellence sanctioned for the postgraduate training in the mental health. Apart from that, 47 postgraduate departments in mental health established nationwide. These initiatives aim to increase the availability of the psychiatrist, psychologist, and mental health specialist, especially in the underserved region of the country. Telemanus health, it is also complemented physical infrastructure with digital outreach through Telemanus helpline, where they can give you consultation over the call, and these are multiple ways through which a person can take the benefits. Where does India fall short on the mental health funding? Most important thing, India's mental health funding, though it has increased from some 683 crores to 1,898 crores. That means there's a 3-time increase in the funding. However, critics argue that it raises deeper problem of chronic underinvestment. This sudden rise shows the deeper problem of underinvestment, chronic underinvestment. Out of that, they stated that, however, the health is just 2% of the GDP. Out of this GDP, only 2% out of this health data, health funding, only 2% goes to the mental health care. Hence, it is still, there's lack of funding. Which, however, and this is also mismatch between spending and need. The underinvestment becomes stark when weighted against, first, India's highest suicide rate and depression burden, massive treatment gaps, and also economic losses due to untreated mental illness. And also there's an overemphasis on the tertiary institutions, for example, NIMHANS and Center of Excellence. However, we must promote community-based services, early intervention models, and preventive and promotive mental health care, so that we can tackle it on the base level itself. Utilization gap compounds the problem. Beyond low allocations, there's also a utilization issue. Health experts argue that better utilization requires decentralization planning and community-led models, not just increased funding. So these are the challenges, and government must come up with a whole of community approach, integrate mental well-being into schools, and strengthening workplace policies, so that at the ground level there is awareness. Once there is awareness, we can tackle with the early symptoms, and also if there is symptoms, we can have at a primary level with the community-based services, we can have a treatment at the ground level also. So these are some steps that needs to be taken to tackle the issue of mental health in India. Let's have a mains question. For that, India faces a rising mental health burden despite policy interventions. Analyze the gaps in implementation and suggest a multi-dimensional strategy to address mental health challenges. Okay, so first of all, health burden. You have to maintain the health burden from over here, the NCRB data, and the sample registration system under Ministry of Home Affairs. They have mentioned these data. You can mention over here, for example, one out of the 3 global issues with respect to suicide and mental depression is in India. Critical youth stage, the age group is 15 to 29. Okay, then they're asking, analyze the gaps in implementation and suggest. Then you have to mention, first of all, funding, resource shortfalls, as I've just mentioned, that if you see, we have very limited psychiatrists and psychologists as compared to the global standards. Then you have to maintain the resource shortfalls with respect to the funding, infrastructure, hospitals, and also awareness. Then what needs to be done? India must go for community-based services, early intervention models, and also preventive and promotive mental health care in sync with the promotion of center of excellence and tertiary hospitals as well for the improvement in the mental health care system. Okay. Now, next theme that we'll be taking up today is polity and governance. What is there? First news is that proposal to ban non-Hindus from entering Char Dham Yatra. The proposal was raised by the Badrinath Kedarnath Temple Committee, citing priest demands while the Gangotri and Yamunotri communities are reviewing similar moves. So basically, the Chota Char Dham Yatra, that is Badrinath, Kedarnath, Yamunotri, Gangotri, out of them, Badrinath and Kedarnath Temple Committee is considering to ban non-Hindus from entering Char Dham Yatra. Now, what is the argument of the critics on this? First, it may be a violation of Article 19, which provided right to free movement. Apart from that, it mentioned that Article 25, which allows a person to maintain religious denominations, are not absolute. Failures to meet the essential religious practices that was highlighted by the Supreme Court in the Shirur Mutt case, they stated that the elements which are important for the existence of the religion are known as the essential religious practices, and only essential religious practices would be acting as a fundamental requirement for a religion if they are going under Article 25 and 26. Now, about Badrinath Kedarnath Temple Committee, it is a statutory committee. This is something you please remember. It was United Provinces Sri Badrinath and Kedarnath Temple Act 1939, which is amended in 1948. So these committees, how they will function: administration of governance of temple affairs and funds as a trustee of the temple. State government also have some role with respect to the executive appointments. For example, chief executive officer, supervisory authority, control over religious functionaries, financial oversights, for example, audit of the temple funds, and administrative accountability. Now, what is proposed bar on the non-Hindus based on? What are the grounds? First, Article 25 and 26. Temple entry rules fall within the domain of the religious autonomy. Okay, Article 25 guarantees that the freedom of the conscience is the right to propagate religion. Article 26 gives religious denominations the right to manage their own religious affairs. Article 25, Clause 2, Subclause B, if you see clarification, this includes Sikh, Buddhism, and Jains within the legal definitions of Hindu for temple entry purposes. Hence, committee argues that the move is not exclusionary within the Hindu fold. Judicial precedents supporting this ban as well. First of all, Madurai bench of the Madras High Court in 2024 directed the authorities to display boards stating that non-Hindus are not allowed beyond a Kodi Maram, which is a flagpole. The court accepted the argument that first, temples are the religious spaces, they are not tourist places. Non-Hindus practices, for example, non-vegetarianism food or the prayers of other religion within the temple premises can erode religious sanctity. Hence, the court upheld that protecting Hindu religious practices outweighed the concerns about the non-Hindu sentiments within the temple premises. This rule is cited as a legal support for the similar restrictions elsewhere. Okay. Then this essential religious doctrine, that was only those practices integral to the religion are protected under Article 25. This was given in the Supreme Court, the Shirur Mutt case, and it was also upheld in the Sabarimala judgment as well. Now, what are the challenges? First is risk of discrimination and exclusion, maybe the religious profiling of the people. Second, practical administration concern with respect to the high footfall in these tourist places, in these temples. This is very difficult to have a religious verification. Also, political and symbolic objections. Opposition parties argue that the move is symbolic politics rather than religious necessity. What needs to be done? First, legal clarity first. Any restriction should comply with the Article 19, 25 and 26 to pass the essential religious practices test. Better focus on the conduct, not on the identity. Conduct must be in sync with the culture of the place, not the identity. Stakeholder consultation. Engage priests, devotees, legal experts, and state to build consensus. And at the end, we must go for the judicial review in case any of the fundamental rights are violated. Okay, so let's have a prelims question. It was there. Previously, UPSC has also asked this question on the religious sect and community. Now you have a prelims probable question for. The Constitution guarantees unrestricted entry into all religious institutions. This is an incorrect statement because it is not unrestricted. We have the qualified restrictions. Religious denominations can manage their own affairs under Article 26, which is a correct statement. The state cannot regulate religious practices under any circumstances. So, India, we do not have this sort of negative secularism. This is an incorrect statement. Answer would be 2 only. Now, Mains PYQ, if I tell you, right of movement and residence throughout the country of India are freely available to Indian citizens, but these rights are not absolute. Okay, so this was the question UPSC has asked, and these are not absolute, and on that basis, this temple committees is also considered to have a religious religious allowance of the people who can visit the temples. Okay, so you can use this as an argument as well. Now discuss the constitutional balance between religious freedom and inclusivity in the context of restrictions on entry into the religious institutions. So first of all, what is this constitutional balance? That is Article 19, right to movement, and also the Article 25 and 26. So you have to go for doctrine of harmonious construction between the two. All right, temple access and religious restrictions. So we have the practices, and also there's a demand for inclusivity. Criticism and concern is the risk of discrimination based on the religious profiling and also the constitutional limits. So these could be the ethos which may erode the pluralistic ethos of the Indian society. However, we have the legal way forward. First, focus on conduct, not identity, and also stakeholder consultation could be the steps that needs to be taken. So try writing this question. Next news is about the denotified tribes. What they are asking? They are seeking a separate column in 2027 census and demanding constitutional recognition through a distinct schedule similar to that of the scheduled caste and scheduled tribes and other backward classes to ensure formal identification and targeted welfare measures. This is the demand raised by the denotified tribes. Before that, you should know who are denotified tribes. So these are the communities basically which are labeled as criminal tribes under the Colonial Criminal Tribes Act 1871. Which was later amended into 1924, which allowed British government to register, surveil and control entire community on the presumption that they were addicted to some non-billable offences. Okay, many of these nomadic and semi-nomadic groups claimed that community leaders were those who resisted against the colonial rule, and that is why they were stigmatized. After the act was repealed in 1952, these communities were denotified and came to be collectively known as denotified nomadic and semi-nomadic tribes. Previously also, there were some successive attempts of their classification, so you need to remember these committees. For example, Ananthaswamy Iyengar Committee, 1949, the report of this committee, the Criminal Tribes Act was repealed. First backward class committees headed by Kaka Kalekar, Lokar Committee, Mandal Committee, Renke Commission, Idate Commission in 2017 also. Ethnographic studies also shows that by the Niti Aayog, it stated that the Anthropological Survey of India and the Tribal Research categorized 268 previously unclassified communities, found 63 communities not traceable and recommended inclusion of 179 of them into SC, ST and OBC list. Fresh classification of 85 communities out of 179 and then reclassification of 9 tribes. So that means they are largely they have not been given the due recognition, and that is why they are demanding the same in the upcoming census. Now, what are the challenges faced by these tribes because they are not recognized properly? First is political misclassification. The leaders argue that they are crowded into the SC list by the politically stronger communities. They cannot enter into the ST list because of the high eligibility threshold and lost within the OBC list. Means they are not getting their proper due in these lists as well. Second, graded backwardness within the denotified tribes as well. A few of them who were settled, they reap the benefits of the constitutional provisions, government steps and various government schemes. They got the benefits and they got the mobility as well. However, among them, there are some nomadic and semi-nomadic as well. Okay, hence they are asking for a graded backwardness, and because of that, nomadic communities remained severely deprived, socially, economically and educationally as well. Okay, there is also a continuing of stigmatization. Despite the repeal of the Criminal Tribe Act 1871, the local police allegedly continue to treat them as habitual offenders. Historical stigma persists socially and institutionally as well. Also, lack of community certificates. There is a scheme called a SEED scheme which provides states to promote the DNT certificates. Based on that, Government of India can give them exam coachings, health insurance, housing aids and livelihood initiatives to families with annual incomes below 2.5 lakh rupees. However, in the absence of these community certificates, they fail to reap the benefits of the SEED scheme as well. Also, there's a lack of reliable population data. There's no definite national population figures. Without enumeration, policy advocacy become very difficult. Why categorization is necessary? First, It will give them access to the welfare. Once they are categorized, they will get the certificates. They will reap the benefits under the seed scheme as well. Administrative clarity. Wrong categorization traces back to the colonial census will be classified. For example, few tribes are classified as caste and castes are classified as tribes. Organizational mobilization. Without a complete national list, communities remains fragmented and advocacy become very difficult. They don't have the voice. Effective implementation of the schemes, once they are regulated, once they are categorized, they can get the benefits, for example, that of the seed scheme. Implications of the separate recognition. Targeted welfare and quotas, as we have just mentioned, they are graded inequalities, so you can go for the targeted welfare of and the quotas. Administrative clarity to reduce the ambiguity in the beneficiary identification. Recognition of the historical stigma, political consolidation, and also internal sub-classification. There is a possibility that we can further classify them. One which have already reaped the benefits, they could be taken away from the group so that the benefits of these schemes could be penetrated further. Okay, so there was a mains PYQ question. Before that, let's have a look on this prelims question. Consider the following statements. As per the recent amendment to Indian Forest Act, acts related to tribes are very, very important for the exam. That was asked by the UPSC as well. Now you have a prelims probable question. Denotified tribes are originally classified under which of the following acts? Forest Right Acts, Criminal Tribes Act, Government of India Act 1935, Scheduled Caste Order, Sponsored Criminal Tribes Act 1871. Okay, now let's look at the mains PYQ. The crucial aspect of the development process has been inadequate attention paid to the human resource development in India. Can suggest measures that can address this adequacy. Human resource development in India, you can mention the issues of the denotified tribes as well, because they are also the human resource for India, which are not given due training and some other resources. Okay, based on that, try to write this mains question. Examine the socio-economic challenges faced by the denotified nomadic and semi-nomadic tribes in India. Suggest policy measure for their inclusion. First of all, you have to mention what do you mean by denotified tribes. Then you have to mention the socio-economic challenges. For example, we have mentioned over here great backwardness, political misclassification. Apart from that, lack of access to the welfare, lack of reliable data and the welfare access, and there's a, for example, lack of community certificates because of the, okay, then we have this suggested policy measures. Conduct separate census for this denotified tribes, constitutional recognition and the quotas, targeted welfare schemes and community empowerment and education. With this, these were the policy measures that can improve their inclusion into the mainstream society. On this basis, try to write that answer. Okay, next we have is WhatsApp Meta privacy policy case, important for everyone. A Supreme Court bench comprising Chief Justice Suryakant and Justice Joymala Bagchi and VM Pancholi recently criticized WhatsApp LLC and Meta platforms over their data sharing policy, stating that citizens' privacy cannot be compromised and companies cannot exploit personal data under the guise of business operations. What is the background of the case? This was triggered in 2021 when WhatsApp came up with the privacy policy update. It was more like a take it or leave it policy. That means if you want to use the WhatsApp, you have to accept to their policy. If you don't want to use accept the policy, you have to leave the WhatsApp as well. First, regulatory interventions by the Competition Commission of India. We know that the WhatsApp has a very dominant player in the Indian market. Based on that, this policy was more or less to misuse the power into the based on the dominance of the Indian market, and on that basis, Competition Commission of India initiated a suo motu investigation holding that WhatsApp, given its dominant position in India messaging marketing, imposed unfair conditions on the users, and on that basis, it ruled that policy amounted the abuse of dominant power under the Competition Act 2002. And it imposed a 213.14 crore penalty on the Meta and directed the 5-year restrictions on sharing WhatsApp user data with other Meta entities, that's of Instagram and Facebook. Appeal before NCLAT. Meta challenged the order before the National Company Law Appellate Tribunal, which is known as NCLAT, which upheld the finding of abuse of dominance and retained the monetary penalty. However, it set aside the 5-year data sharing ban, stating that cross-platform data integration is standard business practices and such a structural remedy was disproportionate. It also noted that Digital Personal Data Protection Act 2023 would govern data privacy issues going forward. After that, the Meta has appealed in the Supreme Court, and the approach, apart from this 2021 policy dispute, a broader challenge to WhatsApp 2016 data sharing policy, which allowed sharing user data with Facebook, is also pending before the Supreme Court. Okay, in 27, the court referred the matter to a constitutional bench, raising issues of informed consent and right to privacy, because we know right to privacy under Article 21 is your fundamental right. Okay, now what are the arguments given by the Meta and the WhatsApp, and what did the Supreme Court say? Let's have a look. First is consent-based data sharing. Users have an opt-out options. The 21 policy did not compel unlawful data extraction as stated by the Meta. According to the Meta, that the policy was based on the user consent, and user also has an opt-out option. Then they stated that the messages are end-to-end encryption, and WhatsApp cannot access, read, or monetize the content of the chats. Therefore, privacy of the communications will remain intact. Second, limited scope of data sharing. Data sharing is primarily for integration and service improvement. Regulatory framework exists. According to the Meta, the Digital Personal Data Protection Act 2023 now provides a statutory framework for data governance. Compliance with earlier directions, Meta stated that they have deposited the penalty. Newspaper notices were issued informing users about policy changes. The NCLAT has also set aside the 5-year embargo on the data sharing. Hence, they are stating that the Supreme Court should dismiss this plea. However, what Supreme Court said? Supreme Court reaffirmed that the privacy is a constitutional right. The companies cannot play with citizens' privacy and describe the policy as potentially amounting the decent way of committing theft of private information. This is what Supreme Court stated. Illusion of the consent framework amount to the genuine consent, as ordinary users may not understand complex legal languages. Opt-out mechanisms were seen more or less impractical and opaque. Network effect and monopoly concern is also there. For example, not using the WhatsApp, is that something missing in the country, because WhatsApp has a dominant power in the Indian market. Data as economic value beyond privacy. It shifted the debate beyond privacy to the economic value of the behavioral data, questioning who benefits from monetizing users' digital footprint and raising concern of the rent sharing of the data. The court indicated that the Meta files an undertaking not to share data. Otherwise, this may be dismissed or strict interim direction may be issued. So we will be waiting that how Supreme Court will come upon this judgment. What are the core constitutional positions that were emerging in this case? First, privacy is non-negotiable even in commercial digital ecosystem as well. Second, consent must be informed, granular, and meaningful. It must not be coercive. Data may not be treated purely as a commodity. It has economic exploitation, raises constitutional concerns. So these were the questions raised by the Supreme Court. Let's see. Right to privacy was asked as a PYQ as well. Okay, so let's see which of the following articles of the Constitution of India has the Supreme Court of India placed under right to privacy. That would be Article 21. Means they have also asked, e-governance is not about utilization of power of the new technology. That means the user content, user data maybe, but also much about critical importance of the use value of information explained. And this is the use value that is Supreme Court is questioning from the Meta. So you can use that debate in this answer as well. Now let's have a mains probable question for you. Data governance in India faces a dual challenge of privacy and market dominance. Analyze with reference to the big tech platforms. For example, Meta, WhatsApp. So you can see data governance is basically data privacy concern is being challenged. Also, for example, invasive data collection, illusion of consent or the binary choices, market dominance position, India's regulatory actions and challenge. All right, then what needs to be done? We must have to implement meaningful consent is essential, prevent abuse of power, and also bolster regulatory capabilities with respect to the legal backing of the privacy of data. Okay, so let's see how Supreme Court will come upon this judgment. We'll discuss it further. Till that time, try to solve this question. Another news similar to that, the same fundamental right of right to privacy is, does the right to be forgotten apply to the online news? What is the background? The Supreme Court recently issued notice on a plea filed by the Indian Express challenging a December 2025 High Court judgment, Delhi High Court judgment, bringing into focus whether the right to be forgotten can be used to seek deletion of the de-indexing of the past news reports after the accused has been discharged. Okay, what do you mean by the right to be forgotten? Basically, it's an individuals claim to have his or her personal data removed, erased, or de-indexed from digital platforms where its continued availability cause harm or is no longer justified. It is rooted in the broader framework of right to life under Article 21 and also under right to privacy, which was given in the Puttaswamy case judgment, particularly in the digital age where information remains permanently and that information could be misused. Now, privacy is recognized as a part of fundamental right under Article 21 in the Puttaswamy case judgment as well. What is the legal position of right to be forgotten in India? India does not have a separate codified right explicitly termed as right to be forgotten. However, we know under the Digital Personal Data Protection Act 2023, it provides for the right to erasure. Okay, now, right to erasure under DPDP Act 2023, it's a user initiated that imposes obligation on the data fiduciaries, means the entities which are collecting the data, for deletion of a user personal data when consent has been removed, withdrawn, or the purpose for which data was collected has been fulfilled. Okay, however, Act does not automatically mandate ensure in all cases. It balances competing legal obligation as well. Okay, if I tell you what is the strongest measure is given in the European framework of GDPR, which stated that most developed articulation of right to be forgotten. It stated that the individual can have the right to erasure if the data is no longer necessary for its original purpose, consent is withdrawn, and no other legal basis exists to store the data was processed unlawful, or the individual objects to processing and no overriding legitimate ground exists to store the data. If the data has been already made public, controllers must take reasonable steps to inform other processors to erase links, copies, or replication. So that means in this GDPR, right to be forgotten is more strong as compared to that of in India. Now the next question is right to be forgotten is an absolute right? Both in Europe and India, it is not absolute. Data controllers may refuse deletion when processing data is necessary for, first, freedom of expression and information, second, compliance with legal obligations, public interest, for example, public health, finance, official duties, scientific and historical or stats research, establishing, exercising, or defending legal claims. Thus, this balance privacy with the transparency and public record preservations. How judicial evolution is in India? You see, in November 2025, Patiala House Court ordered Google to remove links to news reports and report relating to the bankers later acquitted, citing reputational harm and dignity concerns. March 25, Punjab and Haryana High Court directed removal of petitioner's name from court proceedings related to an FIR, observing that criminal accusation should not continue to haunt individuals after exoneration. February 2025, Rajasthan High Court held that juveniles enjoy an absolute right to be forgotten under the Juvenile Justice Framework to protect rehab and future prospects. July 24, Supreme Court stayed a Madras High Court order directing removal of judgment from Indian Qanun, observing that court's judgments are public record and media platforms are entitled to publish as them they are. Now let's see what will happen in this case. Supreme Court judgment would be there and then we'll be discussing the same. Based on that, you again have this PYQ on right to privacy that was asked by the UPSC as well. Okay, now let's have a prelims discussion. Right to be forgotten is most closely associated with which of the following? It is related to the right to privacy. Mains PYQ, the Right to Information Act is not for all citizens. Empowerment alone. It essentially redefines the concept of accountability. So this is more important. Accountability also include right to be forgotten. So let's see a mains practice question. Examine the conflict between the right to be forgotten and freedom of press in India. Highlight the steps taken by the judiciary to mitigate the conflict. Right to be forgotten and the freedom of press, which is a cornerstone of democratic society. So judicial steps we have just discussed. These are the steps that you can mention that Patiala House Court, Punjab and Haryana House Court, Rajasthan High Court, and also the Supreme Court has ensured that the judgment is public records and media platforms has the right to publish them in their original format as well. More data we'll be adding once the judgment for this would be out. So in the again change of the nomenclature, Prime Minister office has recently inaugurated Seva Tirth in Delhi, an integrated complex housing the Prime Minister's office, Kartavya Bhavan 1 and 2, signaling a major administrative consolidation in the shift in the focus functioning of the union executives. What is about Seva Tirth? What is it? Meaning and philosophical foundation. It combines two Sanskrit terms. One is seva, that is service. Tirtha is a sacred place or spiritual crossing that helps one overcome obstacles. Together, these terms symbolically redefine governance as a sacred duty of public services rather than the exercise of authority. So this is the part of behavioral change. Okay, it reflects a shift from satta, that is power, to seva, that is sacrifice. Also, the concept aligns with the ethos of Nagarik Devo Bhava, that means citizens is akin to divinity, positioning governance as accountable, ethical, and service-oriented. Integration, Central Vista Project, Seva Tirth consolidates key executive institutions, for example, Prime Minister's Office, Cabinet Secretariat, and National Security Council Secretariat that were earlier dispersed at different locations, and that was difficult. Architectural philosophy and design, if I discuss, it is based on the Chalukyan temple architecture that was in the 11th to 13th century in Karnataka. Also, the Buddhist stupas reflected in stone screen works, entrances, and geometric floral motifs. Material and visual identity. It is constructed in a white and red sandstone, forms conveying durability, dignity, and continuity in India's institutional heritage. It also has some modern features. For example, open plan collaboration offices, high-tech India House for international summits, high-performance building systems, and a 4-star green building standards. Okay, functional and technological features are very obvious. Digital integrated of the offices of the different departments, structured public interface zone, centralized reception systems, streamlined visitors management, advanced surveillance networks, emergency response infrastructure, and also encrypted communication systems to have a communication with the different ministries and department. Let's see, evaluate the role of administrative outreach programs like Seva Tirth in improving governance and citizen engagement. So you can mention about this is a philosophical foundation, changing of the mindset from satta to service, that is the power to service, and also promote accountable, ethical, and service-oriented things. You can also pick it from the symbolic value of the governance, for example, direct public access and a symbolic value of governance, where they will be giving centralized reception system for the visitors management as well. Okay, so on that basis, you can mention this question. PM Rahat is the Prime Minister approved the launch of PM Rahat scheme, which is a road accident victim hospitalization and assured treatment scheme. It's a national emergency healthcare initiative to provide immediate cashless medical treatment to road accident victims in India. What is the objective? The objective is that we should ensure that no life is lost due to lack of immediate medical help, medical treatment after the road accident. To remove financial barrier which led to the delay in treatment, also improve coordination between emergency responders, hospitals, and police. Studies indicate that nearly 50% of the road accidents deaths are preventable if victims receive medical care within the golden hour. So golden hour, the first 60 minutes after an accident, when prompt treatment can drastically reduce fatalities. What is the significance of the PM Rahat scheme? First is life-saving focus. It encourages victims to be admitted immediately without the fear of treatment cost. Financial protection reduces out-of-pocket expenditure for the families during a time of emergency. It also strengthens emergency care, encourages good smartians, that means clear guidelines and cashless treatment provisions reduce hesitations among bystanders to take the person to the hospitals. What are the key features and benefits of the scheme? First is cashless treatment cover up to 1.5 lakh, irrespective of the type of the road, whether it was a national highway, state highway, or road of the rural area. Coverage duration, treatment costs are covered for up to 7 days from the date of the accident. Stabilization window, non-life threatening up to 24 hours, life threatening up to we have 48 hours. Integration with emergency services, for example, ERSS 112. Technologically driven framework, the scheme will use a digital ecosystem to ensure seamless operations. Okay, so that means we have a funding and reimbursement mechanism. Motor vehicle amendment fund would be there. Timely payment to the hospitals within 10 days, ensuring financial certainty for the healthcare providers as well. So let's see, PM Rahat Fund is primarily associated with infrastructure financing, road accidents, skill development, health insurance. Answer would be road accidents. Alright, next is a slight amendment into the industrial code bills which were already amended into 2020. What is this? So we know that bill were amended into 2020 which replaced 3 major labor laws. For example, Trade Unions Act 1926, Industrial Employment Standing Orders 1946, and Industrial Dispute Act 1947. This governs recognition of the trade unions, notice periods for strikes and lockouts, standing orders, investigation, settlements of the industrial disputes. These things were taken care into the 2020 amendment. Then what is in the recent amendment? The bill contains a section that maintains continuity of the prevent legal confusion. It addresses potential misunderstanding about the delegation of the power, because repealing of law is a power of parliament. So this is made clarified with this amendment, that the previous laws were repealed by this act itself, which is a power of parliament. It's not a excessive delegation is not there. Secondly, the bill seeks to avoid future unwarranted complications by clearly stating that repeal has occurred through the operation of section 104 itself of the amendment bill, which was passed by the parliament. Retrospective operation is deemed to have come into force of 21st November 2025. This ensures legal continuity and remove any scope for litigation over the status of repealed laws between the commencement and amendment. So it will reinforce the doctrinal clarity. What is this? It ensures that repeal flows from the parliamentary authority. It is not being delegated, or it is not based on the executive order. So this is the two clarifications were added, and that is why this was the amendment bill 2026 was in the news. Okay, now this broader review framework will include 4 labor laws which are aimed at consolidation and simplification of the labor laws, uniform wage standards, formalization of employment relations, and also dispute resolution mechanism. Okay, so industrial employment standing orders central amendment rules were asked by the UPSC previously as well. For this is a prelims probable question on this news currently. Consider the following. It consolidates labor laws related to the industrial relations. It abolished trade unions. It does not abolish trade relations. In fact, it gives the recognition to the trade union. The statement 2 would be an incorrect one. It introduces provision for the strikes and layoffs, which is a correct statement. It has the provision for the lockouts and strikes. Okay, so answer would be B only. Now, labor reforms aim to balance flexibility and worker protection, analyzed with reference to the recent amendments in industrial relation laws. So these are the things that you can pick from this article. All right. Now, major news in this edition is that no confidence motion against Lok Sabha Speaker. More important for you is what is the procedure of no confidence motion and why there was a no confidence motion against the Speaker and its impact on the parliamentary democracy in India. These are the few themes that you must understand. First, what is the procedural framework? So, notice of the resolution based on the rule 200 of the Lok Sabha. Any member intending to move the resolution must submit written notice to the Secretary General of the Lok Sabha. First thing. And this furnish full text of the resolution. The notice must be given one or more members. At least 14 days prior notice is mandatory before the resolution can be moved. Okay. Admissibility requirements. What are the requirements? It is given in the rule number 200 capital A. The charges have to be very, very specific. You cannot go for the open-ended interpretation. Be clearly and precisely worded. Not contain arguments, inferences, ironical expressions, and imputations of the defamatory statements. That is not allowed. It ensures procedural discipline and prevents politically motivated or vague allegations. Once these things are met, the Secretary of the Lok Sabha will accept the notice. Now, second, there will be leave of the House. That is given in the rule number 201. After the 14-day period, the motion seeking leave of the House, that means the permission of the House, basically, move the resolution to enter in the list of the business. The day is fixed by the presiding officer. Understand that once the no confidence motion proceedings is taken against the Speaker, Speaker will not preside. This would be presided by the Deputy Speaker. But you know, in the Lok Sabha, we do not have the Deputy Speaker. So any other member that was under Article 95 Clause 2 will preside over this meeting. The member in whose name the motion stands must formally move it when it's called no speech is permitted at the introduction stage. What is the threshold requirement? It must have the support of 50 members. If fewer than 50 members rise, the motion is failed. If 50 or more members rise, the leave is granted. That means permission is granted to move the motion, and the presiding officer will fix the date of discussion. That would be within 10 days. Then you have the discussion stage that is given in the rule 202 and 202 capital A. Discussion should be strictly confined to the charges mentioned in the resolution. No extraneous political debate is permitted. Time limit for ordinary, it is 15 minutes time limit is there, but the person who has moved the motion may get some little more time, but it is also based on the discretion of the chair. Voting, it must be passed by the majority of the all then members of the house, effective majority. What is effective majority basically? So effective majority is the majority minus total majority of the house minus the vacancies. This is the effective majority. So of the effective majority, you have to pass it by a simple majority. Okay. If it is passed, speaker is immediately removed. If it is defeated, the speaker continues into the office, and this no confidence motion against the Lok Sabha Speaker Shri Om Birla has been defeated as well. Okay, now let's see whether past instances, was it the first one? The answer is no. The first one was in 1954 itself against the Ganesh Vasudev Mavalankar, also known as the father of Indian Parliament. He was the first speaker of the Lok Sabha, faced the removal notification. After that, we have in 1966, the motion was moved against Sardar Hukum Singh, then the Balram Jhakar, and all three cases the motion did not succeed and the speaker continued in the office. That means it was the fourth incident. All right. So that is there. There you have the PYQ. With reference to the Speaker of the Lok Sabha, consider the following statement. While any solution for the removal of the Speaker of the Lok Sabha is under consideration, he or she shall not preside. Okay, he, she shall not have the right to speak. Speaker has the right to speak. He, she shall not be entitled to vote on the resolution in the first instance. That is also correct. This is correct. Answer would be 2 and 3 only. Now let's go to the mains question. Discuss the procedure and significance of removing the Speaker of the Lok Sabha. How does it impact Parliament neutrality? Procedure, if I tell you, we have given the procedure over here. There's the procedure. Then they're asking about the significance of removing the Speaker. Now, what is the significance of removing the Speaker? It may have the neutrality concerns, majoritarian polarization, procedural integrity, and the governance impact. Alright, how does to impact parliamentary neutrality? We must promote further communication between the treasury bench and the opposition, and the Speaker must ensure that he or she must uphold the constitutional morality. Okay, with this line you can conclude this question. Now there's a question. What questions can Lok Sabha ask? What happened recently? The Prime Minister office has recently informed the Lok Sabha Secretariat that questions related to the PM Care Fund, Prime Minister's National Relief Fund, and the National Defence Fund are inadmissible in the Lok Sabha, as they are made up of voluntary public contribution and not from the allocations from the Consulate Fund of India. This is in news, but there are some issues. First, who decide what questions could be admitted in the Lok Sabha? First, initial scrutiny is done by the Lok Sabha Secretariat. It should be based on the compliance of the rules of procedure and conduct of business in the Lok Sabha. Final authority remains with the Speaker of the Lok Sabha, which takes the final decision on the admissibility. Rule 41 of the rules of procedure and conduct of the business stated that admissibility of the questions asked by the MPs during the question hours, it stated that the question must seek information on a matter of public importance within a specialized cognizance of concerned minister. It must satisfy specified conditions, including that first, it does not relate to the official secrets, it is not sub judice, no irony or defamation, no repetition. It should fall within the primary concern of the government of India, and this is the issue which the PMO has asked, that this is based on the voluntary public contribution and not allocations from the Consulate Fund of India. That means it is not the primary concern for the government of India. Does not pertain to the bodies or person which do not primarily responsible to the government of India against the same argument. No ordinarily exceeded 150 words. The question should not exceed to the 150 words. Okay, so this is happening over. But what happens once the question is admitted into the Lok Sabha? It is forwarded to the concerned ministry based on the admissibility of the Speaker, and the 15 days time is given to the minister to respond. First, if ministers has some sort of objection based on it violates admissibility rule, involves highly confidential or national security matters, or may adversely affect India's foreign relation, it may formally request the Lok Sabha Secretariat to disallow, stating the reason. To promote the transparency, the Lok Sabha Secretariat will publish data on the number of questions received and answered, ensuring procedural transparency. It would be there. Now, however, such step that the PMO has outrightly rejected that these questions could not be asked in the Lok Sabha are very unusual. The power to decide admissibility rests solely with the Speaker of the Lok Sabha. Admissibility is assessed question by question basis, and there is no provision of an umbrella ban. If a ministry finds that the question is problematic, it requests to Secretariat to disallow that specific question rather than issuing a general directive against the topic. Now, what could be the implications of government body preemptively seeking to block questions? First, institutional friction, because it may have encroached on the powers of the speaker with respect to the deciding what questions could be admissible in the Lok Sabha or not. Weakening parliamentary oversight. Question hours are the things due to which Lok Sabha has an accountability over the executives. Precedence risk. It could set a precedent for the executives to shield entire subject from parliamentary interrogation. Transparency concerns. Limiting information with respect to the bodies, especially such as public funds and public interest are involved. They may raise a question with respect to the reduced transparency in the governance. Judicial and parliamentary procedures. Such disputes may promote more cases in the judiciary and it may lead to the judicialization of the parliamentary procedure. Political optics may view it as an executive overreach against the power of the Lok Sabha and the speaker. Okay, so let's see a question. There was a PYQ of India exercises control over the functions of the Council of Ministers through. Question R is one of them. So we have a prelims probable question for you. With reference to the question R of the Lok Sabha in the powers of the speaker, consider the following statements. Question R is the first R of the sitting of the Lok Sabha devoted to the questions of the government. The speaker has the authority to decide the admissibility of the questions of the Lok Sabha. All questions submitted by the members must be admitted if they relate to the matters of public importance. This is an incorrect statement because they may reduce, if they may deny, because if it is led to, it may violate the friendly relations with the neighbors, or it may be based on the Official Secrets Act. Supplementary questions can be asked only if the speakers permit. This is a correct statement. So statement 3 is an incorrect one. Answer would be 1, 2 and 4 only. Now, let's see the mains question. More important for that, to what extent does the control of speaker over admissibility of questions strengthen and constrain parliamentary oversight? Analyze. Speaker has the power to accept. So to what extent it may strengthen or constrain parliamentary oversight, this you have to analyze. So you have to mention if speaker will analyze, it will ensure that it is based on the rules. It is admissibility decision, it is oversight, promote oversight balance. However, on the other side, if speaker is biased, he or she may not allow the questions which are not comfortable to the government. So that is how they can constrain parliamentary oversight as well. Okay. So again, what is the way forward is that we must ensure that the transparency should be prevail and speaker should go based on the constitutional morality. Okay. Now, next thing is related to the parliament. Again, can an MP and a party spokesperson represent as a state special public prosecutor? Because whether the question is basically whether it is an office of profit or not. Okay, so let's see. Recently, a key ruling, Mumbai Session Court rejected a PLA to remove Rajya Sabha MP lawyer Ujjwal Nikam as special public prosecutor in 2012 murder case, holding that his role as special public prosecutor does not constitute an office of profit under Article 102, Clause A, Subclause A of the Constitution, thereby allowing him to continue. What is the case background? Case background is that there was a murder case in 2012 and on that Ujjwal Nikam has been serving as a special public prosecutor in that case since 2012. Recently, he got a nomination in the Rajya Sabha and after that there was a PLA in the court that asked him for the removal as SSP, questioning whether a sitting MP can continue. Hence, the court has allowed that he can continue. Now, why? This court stated that it is a there is no violation of office of profit. The court held that Article 102(1)(a) concerned disqualification for being an MP, not eligibility to function as an SPP. It is not a permanent government office and there is no bar under CRPC or BNSS which preventing an MP to serving as a special public prosecutor. Now, limited judicial interference in executive appointments. The court reiterated the appointment of an SSP is a policy decision of the state government and court ordinarily do not interfere in such matters. Relevant judicial precedents, if we see Jaya Bachchan versus Union of India case where the court stated that disqualification of Rajya Sabha MP holding the post of profit is one capable of yielding pecuniary gains even if the person has actually withdrawn remunerations or not, it would be considered as an office of profit. Srimati Kanta Kathuria versus Manak Chand Surana clarified the meaning of office. An office implies a substantive permanent position that continues irrespective of the holder. Third, they stated that state of Maharashtra versus Prakash Prahlad Patel case, the court should not ordinarily interfere with the executive policy decisions. Okay, so we have a PYQ questions on the disqualifications. Based on that, we have a mains prelims probable question for you on this. Article 102 of the Constitution of India, consider the following statement. It deals with the disqualification of the membership of the parliament A person shall be disqualified if he holds an office of profit under the government of India or state government. Questions regarding disqualification of the member of the parliament are decided by the election commissions of India. This is an incorrect statement. It is done by the judiciary. So answer would be 1 and 2 only. Okay. The next is Vibrant Village Program 2. Launched by the Home Minister. It has a budget of 6,839 crores and it was launched in Assam. What is Vibrant Village Program Phase 2? First, understand just few difference with respect to the first phase. This is second part is a central sector scheme. First was a central sponsored scheme. Okay. It will development of the villages along international borders, excluding the villages which were covered under the Vibrant Village Program Phase 1. Okay. So this is also the coverage implemented by Ministry of Home Affairs. What are the objectives? There are few objectives. First, improve living standards in the border villages, generate sustainable livelihood opportunities, prevent out migration, community participation in border management, strengthen border security and trans-border crimes, integrate border population with the national mainstream society. Alright, so what are the key features? First, it will promote a saturation-based approach that will all selected villages with identified border blocks will be receive complete coverage in key infrastructure, for example, all-weather road, telecom connectivity, television connectivity, electrification and convergence model. This model will have a convergence from all the other schemes, government schemes. So, for example, you have the Pradhan Mantri Kisan Sadak Yojana. Okay, so for example, you have the Pradhan Mantri Gramin Sadak Yojana. On that basis, that would be used to make all-weather road connectivity in this Vibrant Village Program. This is a convergence model. Livelihood promotion through tourism and cultural heritage promotion, skill development and entrepreneurship. Horticulture and cooperatives would be promoted to promote livelihood opportunities, and also strategic village identification. The villages will be selected based on the proximity to international borders, security sensitivity and the strategic relevance. On that basis, these villages will be selected in the Vibrant Village Program Phase 2. Okay. Now let's see. Vibrant Village Program primarily focuses on coastal areas, border villages, urban slums or tribal forests. It is border villages. Okay. Now we have a mains question. Border area development is critical for national security. Okay. Evaluate the role of programs like Vibrant Village Program Phase 2. What they are promoting: infrastructure, security, enhancement and development, boost connectivity. It would for citizens also and for the mobilization of armed forces also. Support livelihood and tourism. It will promote sustainable livelihood. It will promote economies. So it will reduce out migration. People will be synced with the mainstream society. So they will be acting as an ear and eyes of the security forces, and also promote surveillance and security, so that it will promote border management. With these things, you can answer this question. The next is public trust doctrine, important for you. Recently, Andhra Pradesh High Court in this Sankul Nagarjuna versus State of Andhra Pradesh case recently dismissed a writ petition challenging the closure of an alleged 30-foot road, holding that the banks of the bounds of the water bodies are integral part of the water bodies and it must be protected. Any encroachment to these water bodies should be treated as a violation of public trust doctrine. What is public trust doctrine? It is principle of environmental law, first thing, okay, which holds that certain natural resources such as water bodies, forest, air and ecologically sensitive lands are held in state in trust of the public. State is not an owner, it is a trust in public, and it cannot be transferred, alienated or used in a manner that harm public interest or future generation. If state do this, this would be a violation of public trust doctrine. What are the objectives of this doctrine? First is protect natural resources, prevent alienation of the natural resources, impose fiduciary duty on the state to act as a trustee, not an owner, promote sustainable development by being ecologically and promote growth, enable judicial review for state inactions affecting public resources. Core features of the public trust doctrine, if I tell you, first is state is a trustee, it is not an absolute owner. Doctrine protects intergenerational equity, that means it promotes sustainable development. Okay. Then it restricts arbitrary executive discretion over natural resources because state is a trustee. If do something which is against the public goods, then it is a violation of public trust doctrine. Alright. Also, it has some constitutional backing. For example, Article 21, right to life includes right to healthy environment. Article 48, capital A, states duty to protect environment. Article 51A, subclause G, fundamental duty of the citizens to protect the environment. Okay. Now, how Indian environmental jurisprudence has evolved. The Supreme Court constitutionalized the doctrine in 1990. integrated into the sustainable development. The scope expanded from navigable water to include lakes, ponds, rivers, forests, and biodiversity, air, and ecological systems as well. There are some related landmarks judgment, and that was your mains PYQ as well. It was, I guess, in 21 or 22, but this was the similar question was asked based on the landmarks judgment. Okay, so first is Vellore Citizen Welfare Forum versus Union of India case. Supreme Court linked environmental protection with Article 21, that is your right to life. MC Mehta versus Kamalnath case 1996, recognized public trust doctrine in India, held that state is a trustee of natural resources and cannot permit its private exploitation. Hinchlal Tiwari versus Kamala Devi 2001 case, directed removal of the encroachment from ponds and restoration of the water bodies. Intellectuals Forum Tirupati versus State of Andhra Pradesh case 2006, held that government's actions affecting public resources requires rigorous scrutiny consistent with the sustainable development. Now, what are the significance? First, constitutional environmental safeguards, promote intergenerational justice, limit state power, supports sustainable development, and also strengthen environmental litigations. There are some challenges. First is center-state jurisdictional conflicts. For example, natural resource falls under the overlapping constitutional entries, creating federal tensions. Development versus conservation debate, evidentiary and procedural rigor. Environmental writ petitions require strict pleadings and documentary proof, which are very, very difficult. Expanding scope. Uncertainty exists regarding climate stability, air quality, and transboundary environmental harms. Okay, so on that, let's have a prelims question. Public trust doctrine implies government owns all natural resources. That is incorrect. State holds resource interests of the people. That would be the correct answer. Okay, there was a mains PYQ on the constitutional morality where they asked the doctrine of constitutional, explain the doctrine of constitutional morality. Similarly, we have a mains question for you. Explain the public trust doctrine and its relevance in environmental governance in India. Okay, so you have to first of all explain the public trust doctrine. What is public trust doctrine in environmental law? With certain natural resources such as water bodies, the state have the trust in public. It could not be used for private exploitation if it is contrary to the public welfare. Okay, then they are asking its relevance. So you have to mention the relevance. Relevance, you can take it from here. Constitutional environmental promotes integrational justice. These things could be used over here. Then environmental governance, how it is promoting. These are the challenges and what needs to be done. That's how you can write this question. Okay, sound mark, basically something new. So Kingfisher iconic jingle "Ooh La La Laleo" secured a sound mark registration recently. What is a sound mark? That is important for your exam. A sound mark is a non-conventional trademark where specific functions as a source identifiers for goods or services. Instead of a logo or a word, the consumer identifies the brand with some audio clip. Okay, for example, you know Yahoo, then you have this Netflix, Tadam, and also the Nokia startup tune. There were some things with which we can recognize, okay, this particular sound related to that particular brand. Okay, so the key principle involved is that first, if the consumer associate the sound exclusively with one commercial source, it can be qualified for trademark protection. Now, what are the legal frameworks in India? Rule 26, Clause 5 of the Trademarks Rules stated that applicant must submit the sound in MP3 format. It does not exceed 30 seconds. Clear and easy replay, graphical representation of the musical notation. If enables registration of a non-visual mark in a visual trademark registry before 27, if the applicant mainly relied on written description of the sheet music, the applicant must explicitly state that the mark is a sound mark. Okay, this is mandatory now. Otherwise, it would be treated as a word or a device mark. That's all. Okay, registration process of the sound mark in India. First, examination including the test of distinctiveness. Registrar examines the distinctiveness of the sound and similarity with the earlier marks. If the sound should not be most common, generic, or purely functional, or create a clear association with single commercial source. It must not be generic. It must not be common. It must have a purely functional and create a clear association with one single commercial source. Publication, if it is accepted, the mark is published in the trademark journal. Opposition, if any, it would be in the appellate, it would be challenged. Okay, registration certificate is issued if it is unopposed or successful, which is valid for 10 years. It is valid for 10 years, but it could be renewed indefinite period of time. Okay, this you should understand. What is the significance? Why it is so important? Certainly, first is protection of non-visual branding, especially in the time of digital age. right? Commercial asset creation, intangible intellectual property asset has been created. Relevance in digital economy, for example, OTT platforms and mobile apps. Consumer interact is increasingly audio driven, making sound marks selectively, strategically valuable. Okay, so let's have a prelims question for you. Sound marks in India are protected under, it is, please remember, it is under Trademarks Act, not Copyright or Patent Act. Okay. Now discuss the concept of non-traditional trademarks such as sound marks. How do they impact intellectual property rights? So you have to mention what are the significance of these things. You can put it here. First of all, you have to mention what are the sound marks, or you can start with a recent context as well. Then you have to mark what are the significance and how it is being registered in India. Okay. Oh, very important topic is substantive motion. Basically what happened, one MP from the ruling party has a substantive motion against another MP in the opposition party. But for our exam point of view, more important is what is substantive motion. Substantive motion is a self-contained independent motion submitted for the approval of the House and drafted in such a way it is capable of expressing the decision of the House. So this is very, very important. It is self-contained, approval of the House and capable of expressing the decision of the House. Then it is known as a substantive motion. The speaker decides if the motion is substantive or if the matter can be raised through some other means. This is the power of speaker. Now, what are the core elements of substantive motion? First is independence. It must not derive its validity from some other motion. It must be independent. Self-contained drafting. The wording must be complete and clear enough to stand on its own. No reference to some other motions. Decision-oriented structure. The wordings must be complete and clear enough to stand its own, and it must be drafted in such a manner that it must be capable to allow the House to adopt, reject or modify it through voting. Formal notice and admissibility. It must comply with the procedural rules admitted by the speaker. Now, what are the examples of substantive motion? All resolutions, for example, removal of the Supreme Court judge, impeachment of the president, motion of the thanks, election, appointment of the motions, motion concerning conduct of the high dignitaries, for example, conduct of a minister. Such discussions must be initiated through a proper substantive motion, not asked casually. Motion against a member. If a member gives notice for cancellation of another member's membership, censure or removal from office, such actions require a substantive motion because first, it seeks a definite decision of the House. It is independent in nature and it has serious legal and political consequences. Hence, it is known as substantive motion. Now, in parliamentary device, motion is basically a formal proposal made by the member of the House requesting the House to take a specific action. So basically, understand, motion is just a device through which parliament works. Okay, there are different types of motion. For example, you have the substantive motion, substitute motion and subsidiary motion. Okay, so we have motions, we have substitute motion, we have substantive motion, and we have subsidiary motion. All right, substantive motion, it has the resolutions and all these motions are part of substantive motion. Substitute motion, if you see, substitute motion is a motion which is moved in place of the original motion. For example, first motion was raised. In response to that, we have raised another motion which could substitute this motion, is known as a substitute motion. Okay, so it could be a substitute of an original motion regarding a policy, situation, statement or other matter, although they are independently express an opinion, but they are not truly substantive because they depend on the original motion. That means they are not completely independent motion. Okay, subsidiary motion depends on the relate of another motion on ongoing proceedings. That means what needs to be done further, that is basically a subsidiary motion. Then we have the subparts of this. First is ancillary motion, regular procedural steps, that is the bill to be taken into consideration. Then you have superseding motion, for example, moved during a debate to replace the delay to the main question. For example, recommending the bill to a committee. And also amendment motions, so that in order to amend the motions into the resolution. Okay, that is the different types of motions. Distinction, if I tell you substantive motion, it is independent. Substitute motion is not completely independent. Subsidiary motion is also not independent. Can express final decision. Substantive motion, yes. Substitute motion may conditionally, but subsidiary motion is not an absolute which can give a final decision. Procedural status, it is primary, derivative and it is auxiliary. Okay, what is the procedure? Significance of substantive motion. First, it triggers formal debate. Unlike short duration discussion where there is no formal motion before the House, a substantive motion ensures the motion is specifically designed to be voted upon. First, you have to have a debate, formal debate. Secondly, it requires voting. That means substantive motions must put to vote. Third, it records the will of the house. That means it shows the decision of the house, it shows the collective stance of the house, it enables accountability. By requiring a formal motion for things like the conduct of the high dignitaries, the rules prevent members from making casual or off-the-cuff allegations during general debates. Okay, now let's see a question. No confidence motion was asked by the UPSC. We have a prelims probable question for you. A substantive motion in parliament requires a prior approval of the parliament president. No, it is a self-contained and independent. It cannot be debated. This is incorrect. It is only used in Rajya Sabha. That is also an incorrect statement. Answer would be B only. Okay, now let's have a mains question. Differentiate between substantive and procedural motions in the parliament, assess their role in legislative functioning. So you have to mention these things: substitute motion, subsidiary motion, and you have the substantive motion, and also mention the ancillary motion, superseding motion, amendment motions, which helps in legislative functioning. On that basis, you can write this answer. Now next is again with respect to the right to privacy, extent of permissible disclosure in the election of statutory body. What happened? Bar Council of Delhi elections were there, and the council uploaded a voter list which contains advocates' mobile numbers, address, and photographs, leading to a widespread unsolicited campaign outreach. Okay, now there is a petition before the Delhi High Court which challenges the disclosure, raising a broader question: how much personal information can a statutory professional body place in public domain in the name of the elections? Now, what is the law? Bar Council, constituted under the Advocates Act 1961, is a statutory body performing public functions and are therefore bound by the constitutional limitations, including fundamental rights. Okay, under the Digital Personal Data Protection Act 2023, consent is the central principle governing personal data. Processing is generally lawful only when based on free, informed, specific, and unambiguous consent, unless covered by a statutory exceptions. Okay. Now, what is the objections raised in the petition? This is very interesting. First is alleged privacy violation. So the petition terms that the voter list publication as an unauthorized disclosure and misuse of sensitive personal data, which have resulted in unsolicited calls, messages, and canvassing due to the disclosure. Second, constitutional grounds under Article 21 were not taken care of. For example, they stated that it failed the test of legality, necessity, and proportionality. They accepted, okay, that means disclosure of the voter list has a legal provision, but it was neither necessary and nor proportional. All right. Then you have the risk of harm. Public disclosure may enable stalking, harassment, intimidation, identity theft, and cyber fraud and data mining. Violation of Bar Council laws. Cites the Bar Council rules which require the electoral rolls to include only serial number, state roll number, and name of the advocate and address. That means phone numbers and the images may not be, photographs were not required. Digital Public Data Protection Act contains the data collected for the enrollment regulatory purpose cannot be repurposed or publicly disclosed without consent, first thing, and asserts that the council was legally bound to process and disclose data only for the specific purpose for which the data was collected. Okay, these were the objections were raised. Now, what are the implications for that? First, this petition will strengthening the information privacy jurisprudence. The dispute could clearly clarify how limitations and data maximization apply to statutory bodies conducting elections. Okay, courts may more clearly define that necessary disclosure in the electoral context. Expanded accountability of the statutory bodies. Okay, it affirmed that the constitutional oversight applies equally in the digital sphere as well. Irreversibility of the digital disclosure and right to be forgotten. Once uploaded personal data can be endlessly copied, remaining accessible even after the elections are concluded. This engages the evolving right to be forgotten, which we have just discussed, which supports removal or restricted access to the data when in continued public availability lack legitimate purposes. Okay, it will also have a precedent for professional regulators. This ruling in this case would influence how other bodies, medical, chartered accountant company, and member database, how they will be using this member database. That would also be giving a light to this. Way forward, strict application of the purpose limitation. We must ensure that the data should be used for the purpose to which it was stored. Data minimization and tiered access. Publish only core electoral data publicly. Provide additional details if necessary through controlled, authenticated, and access mechanism. Consent and opt-out mechanism should be there. Technical safeguards, for example, encryption, captcha barriers in order to avoid digital attacks, cyber attacks on our digital data. comprehensive election data policy, frame transparent written guidelines aligning electoral practices with the Digital Personal Data Protection Act 2023, and promote privacy standards and proportionality principles in order to maintain, store and publish the data. Now let's have a question. Right to privacy, it was asked by the UPSC. Again, we have the question for you. Election to statutory bodies are always governed by the Representation of the People's Act. This is an incorrect statement. Disclosure requirements aim to ensure transparency in candidate credentials. That is a true. Disclosure of the data aim was to promote transparency, but that was not maintained the proportionality. Okay, court have upheld the right to information of the voters as part of the Article 19(1) subclause. This is also a correct statement. Answer would be 2 and 3 only. Now let's have a mains question. Privacy is essential for dignity, right? That is correct. Yet excessive emphasis on privacy may hinder effective governance. Now that is the question, like application-based question that UPSC may expect from you to write. What they're asking is that, first of all, privacy and data is important for governance, hence it must be balanced. So you have to mention why privacy is important and how data can promote good governance, or you may take hint from the e-governance models. Then you have to ensure how it can effective governance. Also you have to give some safeguards to promote the privacy of the person as well. Okay, that is how you can conclude this answer. So you can take up this from here. This proportionality, legality, necessity and proportionality. Okay, with this you can write this answer. Next is parliamentary friendship groups. Lok Sabha Speaker recently constituted parliamentary friendship group with more than 60 countries to bolster democratic ties. Understand what is this? This is a country-specific group of MPs formed to promote regular engagement with the legislatures of the two nations. Okay, they will serve as an instrument of parliamentary diplomacy, complementing executive-led foreign policy. All right. So initiatives has been led by the Speaker Om Birla with parliamentary friendship groups with the countries over 60 countries. For example, we have Sri Lanka, Germany, US, Russia, etc. They will engage directly with the counterparts, facilitate structured dialogue beyond formal diplomatic channels. Okay, what are the objectives? Is institutional dialogue, regular legislature to legislature engagements and exchange of best practices, support diplomacy, complement executive foreign policy. This is not a standalone. This will complement the executive-led foreign policy. Issue cooperation, collaborate on trade, technology, climate and democratic challenges. Okay, working mechanism, how it would work: delegation visit and reciprocal parliamentary exchanges, thematic dialogues, for example, climate legislation and etc. Study tours and committee-led interactions, and also participation in multilateral parliamentary forums. They are informal but structured platform, not treaty-making bodies, and functionally primarily as a facilitator of the understanding and goodwill of India. Okay, so it will complement the executive-led foreign policy. That means what they have done, there's a group of several MPs. For example, there are two groups, MP1, MP2. They will be US related, this would be UK related, and that's how they have made a group of parliamentary, which are known as parliamentary friendship groups. With respect to other, it will complement India's diplomatic outreach to these nations as well. Okay, so parliamentary friendship groups are formal treaty-making bodies, committees under Ministry of External Affairs, informal groups to enhance bilateral parliamentary relations. This is a correct statement. Okay, previously also there were works on the committees, how they are useful for the parliamentary works. On that line, you have this mains question as well. Evaluate the role of parliamentary friendship groups in strengthening India's diplomatic outreach. Are they effective tools of parliamentary diplomacy? So you have to mention the objectives. What are the objectives? Then also you have to write what are the working mechanism, and then you can conclude how they will be formalizing the Indian diplomacy, and also how they will be contributing and complementing the executive-led foreign policy. Okay, with this basis, you can write this answer. Now, Kerala is now Keralam. The Union Cabinet recently approved a proposal to alter the name of the state of Kerala to Keralam, setting in motion the constitutional process required to change. So basically, in 2024, Kerala Legislative Assembly unanimously passed a resolution requesting the Union Government to amend the first schedule of the Indian Constitution under Article 3 to affect the name Keralam. Why Kerala want to change the name? Linguistic authenticity. The state is called Keralam in the Malayalam language, and first schedule of the Indian Constitution recorded it as Kerala. The Kerala Assembly stated that since the state were reorganized on the linguistic lines in the 1956, the Constitution name should reflect the native linguistic form. Cultural identity and dignity. The assembly stated the using word Keralam restore the historical continuity. Indigenous pronunciation and cultural self-respect. Historical usage. The name Kerala is also mentioned on the Ashoka Rock Edict 2, where it has mentioned it as Kerala Putta or Kerala Putra. Okay, and also demand dating back to Ekya Kerala movement 1920. Alright, historical usage is that Kerala Putra on the Ashokan index also, and few said it is related to the Chera dynasty. Okay, now what is the procedure of the changing of the name of the state? More important for an exam point of view. First, it has to be initiated by the state itself. The proposal must originate from the state government legislative assembly through a formal resolution. Then there is an examination by the union government. It is examined by the Ministry of Home Affairs, who will seek no objection certificates from the key agencies, for example, Ministry of Railways, Intelligence Bureau, Department of Posts, Survey of India, Registrar General of India, and where relevant, Ministry of External Affairs as well, to ensure that no administrative, security or cartographic, postal or diplomatic challenges will be there. Constitutional requirements under Article 3. We know the bill to alter the name of the state can be introduced in Parliament only on the recommendation of the President. This is something you please understand. The President must first refer the bill to the concerned state as well. And once parliamentary approval and notification is passed, once passed by the Parliament, assented by the President, the first schedule of the Indian Constitution amended, and it is required a simple majority. Okay, so what is the procedure? First, state government has to come up with a formal. It would be introduced in the Lok Sabha with the prior permission of the President. Then President will again send the bill to the state concerned, and then it would be passed by the Lok Sabha. Okay, which is passed by a simple majority. Now, what is the significance of the name change to Keralam? Linguistic assertion, linguistic reorganization, 1956, Fazal Ali Commission, and alliance with the constitutional name with the Malayalam usage. Cultural identity and symbolism, administrative and legal clarity, ensures uniformity between constitutional records and vernacular identity, avoids dual usages, for example, Kerala and Kerala in official context. Alright, so let's see the question. Changing the name of the state in India requires approval of the state legislature, Parliament legislation, presidential recommendation. Approval of the state legislature is not required even when President sends the bill to the state for the consideration. That is not binding either on the President or on the Lok Sabha as well. Okay, so answer would be 2 and 3 only. Now, need for diversity in the judiciary. What happened? Recently, a senior Rajya Sabha MP introduced a private member bill to amend the constitution to bring diversity in the judiciary. What constitution provides? It stated under Article 124 that the judges of the Supreme Court are appointed by the President after the consultation of the Chief Justice of India, basically a collegium system now. Article 217 states that the judges of the High Court are appointed by the President after consultation of the Chief Justice of India, Chief Justice of the concerned High Court, and the Governor of the state as well. Article 133 states that seat of the Supreme Court shall be in Delhi or at such a place where CGI may decide with the approval of the central government. Please remember. Now, what is this private member bill all about? The bill seeks to address the diversity deficit and access to justice concern. There are two concerns. First is diversity deficit and second is access to justice. Social diversity in judicial appointments. It mandates that proportionate representation as per population for scheduled caste, tribes and other backward caste, religious minorities and the women for the appointment in the Supreme Court and High Court. That means they want that the appointment should be based on the proportion of the population of these groups. Second, promote regional benches of the Supreme Court so that the person can visit the nearby benches of the Supreme Court. Okay, now what is the need for the bill? Diversity deficit in higher judiciary is very much visible. Parliamentary Standing Committee on Law and Justice has repeatedly noted the diversity deficit and recommended that the collegium system must ensure adequate representation of the marginalized sections. Access to the justice challenge. The Supreme Court currently functions only from Delhi, resulting in high litigation costs for litigant from distant state. There are over 90,000 cases are pending in Supreme Court, so with the regional benches, this pendency may come down as well. 229th Law Commission report also explicitly recommended setting up non-constitutional regional benches of Supreme Court in 4 zones, and Delhi should remain as a constitutional bench. Alright, now what are the challenges hindering in this diversity of the judicial appointment? First, opaque collegium process. Second, absence of constitutional mandate of a reservation in the judicial appointments. Third, elite dominated talent pool. Senior advocates from privileged socio-economic backgrounds are very much over there. Informal network and nepotism, structural barriers, marginalized groups face very limited access to quality legal education, mentorship, and elevation opportunities. Hence, they are not very much promoted to the higher judiciaries. Now, what are the way forward? We must broaden the appointment mechanism. It could be revive a reformed version of the NJSC with wider representation of the members, for example, legislature, bar, and academia, drawing from comparative models like that of UK and South Africa. Okay, so what needs to be done? You have to reform the judicial appointment system so that the people from the minorities, people from which would promote the diversity when it comes to gender, religion, or maybe the caste-based person should also be come into the judiciary at the higher judiciary especially. And we must also ensure that the merit must not be compromised. Okay, so there was a PYQ based on the autonomy of the Supreme Court in India. On this, we have a prelims probable question for you. Consider the following statements regarding the diversity of the judiciary. The Constitution explicitly mandates caste-based reservation in higher judiciary. This is an incorrect statement. The diversity improves representativeness and legitimacy of the courts. Opaque collegium process may hinder the diversity in the appointment. So answer would be 2 and 3 only. Okay. Now, means judicial diversity is essential for inclusive justice delivery. Critically analyze the challenges and suggest reforms to improve representation of the India's higher judiciary. So you can mention what are the challenges, why diversity is important, and what reforms need to be done. That is, you can take the data from over here. Okay, for example, there were very less number of people were promoted into the higher judiciary. The data is given over here. You can use this data. Okay, the next thing that we'll be discussing today is international relations. End of New START Treaty, something very disturbing is that the New START Treaty is expired on February 5, ends a 5-decade legally binding nuclear limits between US and Russia. It raises concern of renewed nuclear arm race and weakened global strategic stability. How it evolved, let's see. Strategic arms limitation talks known as SALT. It was initiated in 1969 and intensified US-Soviet nuclear rivalry. 1972 Anti-Ballistic Missile Treaty, Limited Missile Defense System. Also, Interim SALT Accord froze expansion of the intercontinental ballistic missiles arsenal. SALT II and background. It was signed in 1979. Capped nuclear delivery vehicles, that is intercontinental ballistic missiles, submarine launched ballistic missiles, bombers at 2,250 only. Okay, Interim SALT Accord. It froze expansion of the ICBM arsenal, but US withdraw from this anti-ballistic missile treaty in 2002, accelerating erosion of the Cold War arms control. Okay, it was never rectified because Soviet invaded the Afghanistan. After that, US withdraw from this ABM treaty. All right, then post-Cold War nuclear reductions, we have the START I treaty. It came into force in 1994. It limited the warhead to 6,000 and nuclear delivery vehicles to 1,600 only, 1,600 only. Introduced intrusive verification. For example, inspection data exchanges were there between the US and Russia. Expired in 2009, 15 years treaty after reductions were completed. Okay, then in 1993, we had the START II treaty, but it was collapsed. Aimed to cut warheads to 3,000 to 3,500. Never entered into force because Russia withdrew in 2002 after US exit ABM treaty. Alright, then we have the Strategic Offensive Reduction Treaty, SORT 2002. It reduced the operationally deployed warheads to 1,700 to 2,200 by December 31st, 2012. Alright, served as a temporary bridge until replaced by a New START Treaty. Then you have the New START Treaty, which is the last major treaty. It used to cap warheads at 1,550 and delivery vehicles at just 800. Okay, it required significant reductions compared to the earlier treaties. Strong verification mechanism, annual 18 on-site inspections per site was allowed, ensured transparency through regular data exchanges. Extension and expiry, extended in 2021 for 5 years, expired in 2026 without replacement. Okay, now what are the risks that are there? End of binding limits, so there will be again a nuclear race. Reduced transparency and escalation risk. Miscalculations, weakening of nuclear deterrence, stability, and global non-proliferation concern. The risk may broader. Arm race involve other nuclear powers as well. Okay, so this New START Treaty was a PYQ. Same line, we have a prelims probable question for you. It was signed between USA and China. It was signed between USA and Russia. So answer is 1 is eliminated. It aims to limit deployed strategic nuclear warheads. This is correct statement. It includes verification mechanism like on-site inspections. So it was there. Answer would be 2 and 3 only. Okay, so after this, there's a concluding remark. If I tell you, without a successor framework, the world faces heightened strategic uncertainty, diminished transparency, and the growing arm race, possibility of the new nuclear race among the members, as we have seen that recently US-Iran war is happening because of the nuclear war background. Means discuss the implications of the end of the New START treaty on the global nuclear stability and strategic balance. Okay, so you have to mention what are the implications. This is, we have just discussed: no end of binding limits, reduced transparency and escalation risk, weakening of nuclear deterrent stability, and it may promote the global armed race. Okay, and how it will change the strategic balance, because NPT could also be compromised now. Right, many other nations would like to have a nuclear deterrence, and those who already have, they might go to increase their arsenal, and this may promote instability and lack of strategic delivery. Okay, so you can use this to write the answers. Now, recently elections were concluded in the Bangladesh, and this is a new phase of India-Bangladesh relations, because Bangladesh Nationalist Party led by Tariq Rahman won a decisive mandate in Bangladesh recent elections. What is the historical background? It is a complicated legacy basically. BNP was founded in 1978 by General Ziaur Rahman. It was led for decades by Khalida Zia, now headed by Tariq Rahman, who have won this election. India's ties with BNP were historically been cautious and sometimes strained as well. In the 2001-2006, when they have a coalition government with the Jamaat Islami, they saw strained relations with India. Hasina era followed, which is 2008 to 2024. It has strengthened counter-terrorism cooperation with India, cracked down on insurgent, improved bilateral security ties. However, anti-terror mechanisms were used against the leaders of Jamaat as well as BNP. Now, post-Hasina elections, if you see, Awami League was banned from the elections, and BNP and Jamaat Islami emerged as dominant forces in Bangladesh. Now, what is India's diplomacy after BNP's victory? First, swift outreach from India. Prime Minister Modi congratulated his counterpart in Bangladesh. BNP has also moderated its tone. For example, Rahman avoided anti-India rhetoric during the elections or after the elections. Sovereignty and the non-interference is being pushed by the BNP. They stated that they promote equality and self-respect in external relations, zero tolerance for interference while maintaining cooperations. Okay, then but still there are some key challenges in India in the post-Hasina era. First is the Hasina extradition issue. Her presence in India might be a bone of contention between the two countries. Sustaining economic independence, because Bangladesh is India's largest trading partner in South Asia. Securing cooperation so that the Bangladesh soil should not be used for the actors working against the interest of India. It must not be used to promote the terrorism in the northeast part. Okay, and also the connectivity and development projects, people to people engagement, migration concerns, politically sensitive issue in Indian border states, requires cooperative and balanced management. Guarding against strategic drift, we should ensure that Bangladesh should not be moved towards Pakistan or China, contrary to the interest of India. Let's have a prelims question for you. Which of the following crucial factors are India-Bangladesh relations? Teesta water sharing, border management, defense alliance under Quad. So answer would be 1 and 2 only. Right. Now let's have a mains question, because now BNP's return would be a critical test for India's-Bangladesh relations. On that you have a mains question. Analyze how recent changes in Bangladesh polity can influence India's neighborhood policy and regional stability. Okay, so first of all, you have to mention the recent changes that the BNP has came into the power and how it can influence India's neighborhood, because you have to compare it with the Sheikh Hasina time, and also you have to ensure what steps India should ensure to have the regional stability maintained. So this is how you can pick these things from over here. Okay, so you can mention about the security cooperation, counter-terrorism, cross-border insurgency, Rohingya challenge, economic connectivity, trade and connectivity, Indian investment, energy cooperation, balance with China. Also the regional diplomacy, for example, SAARC, BIMSTEC, geopolitical balance, and also managing the Rohingya issues and sensitive politics. That's how India can ensure a good relations with the Bangladesh also. Right, India-Malaysia relations, expanding strategic and economic cooperation. So recently, Prime Minister Modi visited to Kuala Lumpur. India and Malaysia have signed 11 agreements, deepening their comprehensive strategic partnership. So, historical civilization links we have with Malaysia. For example, we have this cultural and religion trade links, political and diplomatic engagements, comprehensive strategic partnerships since 2024, trade and economic cooperation. Malaysia is the third largest trading partner of India in ASEAN. Then the bilateral reach up to $19 billion. Okay, then we have Malaysia's FDI stands again $1.27 billion in India. Key trade terms: India exports petroleum products, energy, goods, dairy, organic chemicals, and import vegetable oils, machinery, electric and equipment, minerals. Defense and security cooperation, maritime and strategic conversion, going cooperation in the joint exercises, especially in the counter-terrorism shared concern over Indo-Pacific stability, piracy, freedom of navigation, intelligence and capacity sharing. Also, we have a connect people to people connect through the diaspora. Right. So, what are the key outcomes of this meeting? Is a strategic outcome. It's the 11 MOUs were signed covering defense, semiconductor, digital technologies, and health and energy. Framework agreement on the semiconductor cooperation, very, very important for the India as well as Malaysia. Economic cooperation, promotion of trade settlement in Indian rupees and Malaysian currency. Invitation of Malaysian investment in Indian electronics, AI, renewable energy, and healthcare. Counter-terrorism commitment, reaffirmed zero tolerance for terrorism and opposition to cross-border terrorism. That is the stance of India. Emphasis on global cooperation against terror financing and misuse of emerging technologies. If I tell you in the multilateral coordination, alignment on Indo-Pacific stability and ASEAN centrality, Malaysia reiterated support for India's UNSC reform aspirations as well. Okay, so there is a question on ASEAN. We have a question for you for the India and Malaysia, which are significantly influenced by ASEAN framework. Okay, now let's have our mains question for you. Evaluate the Indian-Malaysia relations in the context of Act East policy and Indo-Pacific strategy. You know, sovereign impact, we have ASEAN. Okay, and Malaysia is also the third largest partner of India in ASEAN. Right, that is their Indo-Pacific cooperation, for example, counter-terrorism and also against the piracy, open navigation and safe, secure Indian Ocean, strategic domains, FDI, economic cooperation, defense ties and person-to-person contact. So these things that you can highlight the importance of India-Malaysia relations. Okay, next is India-Israel strategic partnership. At the invitation of the Israeli Prime Minister Benjamin Netanyahu, Prime Minister Modi undertook a 2-day visit to Israel. Okay, and there India and Israel elevated their relationship to special strategic partnership for peace, innovation and prosperity. Key outcomes, there were some special strategic partnership. It was elevated. 27 outcomes. First is in the technology and emerging technology domains. For example, launch of critical and emerging technologies partnership covering AI, quantum, machine learning, cybersecurity and critical minerals. Okay, Indo-Israel Cyber Center of Excellence in India, it would be established. Defense and counter-terrorism roadmap for joint development, production and technology transfer as well, which is very, very important for India's development. Trade and economic cooperation, free trade agreement, a process for a negotiation is going on. Also, Agriculture and Rural Development Center of Excellence established in India with Israeli cooperation to 100. Connectivity and regional cooperation, India, Middle East, Europe Economic Corridor and I2U2, where India and Israel both are part of. Discussion on West Asian tensions with India reiterating support for dialogue and peaceful resolution was there. Now, India-Israel bilateral relationship, if I tell you the background, so this is full diplomatic relations established in 1992. Earlier engagements were not very strong because they were the allies of different camps. India was having its non-aligned movement. However, it was looked more closer to the USSR. However, the Israel was an ally of USA. Defense and security cooperation. So defense is a core pillar of the relationships. Israel is among India's top defense supplier, whether it is missiles, UAVs, radar or surveillance system. Strong intelligence sharing and counter-terrorism cooperation. Agriculture and water management, center of excellence across Indian stem. Israel has established various centers. Focus areas were horticulture, drip irrigation, precision farming and desert agriculture and also desalination. Very, very important for the India's growth. Trade, innovation and technology is also discussed. Now, bilateral trade peaked at some around $11 billion, excluding defense. Okay, the recent decline due to regional instability and trade disruptions. Israel's startup nation model complements India's digital economy. So basically, it's a win-win situation for both of the countries. Now, what is the conclusion? The elevation to the special strategic partnership reflects the maturity and multidimensional nature of the India-Israel ties. Defense cooperation remains central, but the partnership now extends deeply into the technology, innovation, agriculture, connectivity, and digital infrastructure as well. All right. So let's have a mains PYQ. Before that, let's have a prelims question. Consider the following statements. India-Israel cooperation includes defense technology. That is correct. Israel is a major supplier of arms to India. It is also one of the major suppliers. That is correct. Their relationship exclude agriculture cooperation. No, center of excellence has been established by Israel, and hence answer would be 1 and 2 only. Now let's have a mains question. Mains PYQ, if I tell you, India's relation with Israel have of late acquired depth and diversity which cannot be rolled back. Discuss. This was asked by UPSC. Okay, so you can mention that apart from defense, it is diversified in agriculture, trade, semiconductor, critical minerals, and other things as well, which we have just discussed. Okay, so it is now deeply into technology, innovation, agriculture, connectivity, and digital infrastructure. You can mention all these things. So let's see, India-Israel relationship have expanded beyond defense into multiple domains. Again, you can mention, take hint from these things. You can also take hint from these things, that how center of excellence have been promoted, trade and economic cooperation, defense and counter-terrorism, and technology and emerging domains are also things where India and Israel are cooperating with each other. Examine the opportunities and challenges. Opportunities is that India's digital economy, Israel's startup system. India rely heavily on the defense imports. Israel is a major defense exporter. So these things could be opportunity, but challenges is the West Asian conflict basically. Presently, this is the most. Okay, next is India-Brazil partnership deepens with rare earth mining agreement. So recently, during the visit of President Lula da Silva visit to New Delhi, signing multiple agreements, including a significant impact on rare earth and critical minerals cooperation. Rare earth and critical minerals are very important in today's global economy. Okay, and what are the key outcomes? First is this agreement on the critical minerals. Strategic pact to secure access to rare earth minerals aims to reduce over dependence on the China processing dominance, because we have seen China many times go for the blockade. Right, aims to reduce over dependence on China. Brazil holds significant reserve with only 30% export, and now there's a huge opportunity for India to import and Brazil to export. Steel and mining cooperation agreement signed on steel mining and mineral supply chain. Brazil's iron ore capacity can support India's infrastructure growth. Digital partnership, joint declaration on emerging technologies, for example, AI, semiconductors, blockchain, and supercomputing. This reflects India's digital strength and Brazil's tech ambitions. So here India can support Brazil. Okay, trade expansion and visa facilitation. Target to increase bilateral trade to 30 billion by 2030. Brazil extended business visas for Indian passport holders for 10 years. All right. The Rare Earth Agreement marks a strategic deepening of India-Brazil ties, reinforcing cooperation in critical minerals, digital technologies, energy transition, and trade. All right, let's see the prelims probable question. Rare earth elements are important. Why? They are critical for electronics and defense technologies. They are abundantly available globally without constraint. This is an incorrect statement. They are essential for renewable energy technologies as well. So answer would be 1 and 3 only. Right, now see, multi-dimensional implication of uneven distribution of mineral oils in the world was asked by the UPSC. So this uneven distribution is very much significant for rare earth minerals also. Okay, so you can expect a mains probable question. Discuss a strategic importance of rare earth cooperation between India and Brazil in context of supply chain resilience, because India want to reduce the over dependence on the China. We have just mentioned these things, right? So here we have China's, we want to get rid of the over dependence on the China, hence India want to diversify its supply chain, and in this regards this pact with Brazil is very, very important. Okay, critical mineral security, because we know digital economy, your AI, machine learning, defense, renewable energy, very much dependent on this critical rare earth minerals. Okay, then also supply chain resilience, technological advancement, and energy transition could be taken care. Now, India joins Trump's Board of Peace as an observer. Right. So India recently participated as an observer, signaling cautious engagement without full membership. Why it is important? Because India stayed away when the board was announced at Davos. Participation as an observer allows diplomatic engagement without formal endorsement. Questions of legitimacy. First, the board excludes key permanent UNSC members like that Russia, China, France, and the UK. Its expanded mandate to address global conflict has raised concerns about parallel multilateralism that of UN. Flexibility and exit option. India views the initiative as a closely tied to President Trump's personal leadership. Okay, observer status provides room to reassess depending on the board's future direction and durability. Okay, for more detail, you can refer to the recitals of the January where we have discussed this Board of Peace in detail. Now, see, consider the following statement. Observer status in international groupings allow participation in deliberation without voting right. This is correct. All observers arrangements are governed under the United Nations Charter. This is an incorrect statement. Observer participation may serve as a tool for strategic engagement without formal commitment. This is a correct statement. Answer would be 1 and 3 only. Now, there are tensions between Afghanistan and Pakistan, and now Pakistan has declared that they are in an open war with the Afghanistan. So it may look like a strategic point, it may look like a trigger point, but the problem is more deeply rooted. What are the problems? Is the Durand Line dispute. Durand Line, Afghanistan refused to formally recognize the Durand Line and the international border, creating recurring tensions over time with respect to the sovereignty and territorial integrity of the both of the countries. Right. After 1947, after the Britishers leave, Pakistan inherited this position, but Afghanistan rejected the border legitimacy. Kabul even opposed Pakistan entry into the United Nations, continues to the context of border finality. Now, trade and strategic leverage. Afghanistan accuses Pakistan of using trade routes and trade access as a tool for political pressure and deepening mistrust. Pakistan has denied overland trade between India and Afghanistan via Wagha, fueling resentment. Also, mutual resentment. Many Afghans views Pakistan as interfering in their internal affairs. Pakistan considers itself as a long-term supporter of Afghanistan, having hosted millions of refugees and backed resistance movement. Apart from that, there's an India factor as well. Pakistan don't want that India's engagement in Afghanistan should be very high because it feared that a strategic encirclement if Afghan government will have a good relations with India, and that is why the relations between Afghan and India and Afghan and Pakistan is not in a very good shape. So what are the conclusions? So this Pakistan-Afghanistan tensions are not merely episodic or regime specific. They are rooted in unresolved border disputes, historical grievances, strategic rivalries, and competing regional alignments. Okay, so this has recently happened. Let's have a prelims question. The Durand Line dispute is a major source of tension between Pakistan and Afghanistan. This is correct. Taliban-led Afghanistan officially recognizes the Durand Line as an international border. This is an incorrect statement. Cross-border militancy has contributed to the strained relations. This is also correct. Answer would be 1 and 3 only. Right now, the Israel has a strike in Tehran. Israel launched a daylight strike on Tehran, describing it as a preemptive action. Trump confirmed American participation, declaring it as a start of major combat operations aimed at preventing Iran from acquiring nuclear weapon. We just discussed it with the end of New START treaty, that this nuclear war may be started because of the nuclear race. The operation was jointly conducted with a named as Operation Epic Fury. Right, Iran retaliation strikes in Israel, expansion of attacks to the US targets in the Gulf. For example, Al Udeid Air Base in Qatar, you have Al Salem Air Base in Kuwait, Al Dhafra Air Base in UAE, US 5th Fleet Headquarters in Bahrain were all targeted by the Iranian attack. Trigger, collapse of the nuclear talks. What the issue is that stalled diplomacy. The escalation followed the breakdown of the indirect US-Iran nuclear negotiation in Geneva mediated by the Oman. Iran insisted its right to enrich uranium for peaceful use. US demands that Iran strict limitation on Iran nuclear program. Now, rising political rhetoric. President Trump labeled Iran as an imminent threat and the world's #1 terror sponsor. Frustration over stalled talk appears to have contributed to the military action recently. Now, with this, because of the globalization, India has again on a diplomatic test. Less than 2 days after Prime Minister Modi visited Israel, India urged restraint, de-escalation and dialogue as the conflict widened. Diaspora and evacuation issues, strategic and economic stake. Energy, nearly 60% of the energy imports originate from West Asia. Any disruption in the Strait of Hormuz could severely affect India's import. Diplomatic balancing. US-Israel partnership complicates India's position because Israel for defense, US and also Iran. India has to maintain the relationship with all three, and now it has become on the tightrope diplomacy. All right. However, with the US involvement deepens and regional conflicts widen, India's diplomatic space is shrinking down, testing its ability to balance strategic autonomy with regional realities. All right. So we have to have a look on how things will unfold, and let's have a prelims question for you. Consider the following best describe preemptive strikes. What do you mean by preemptive strike? It is basically attack-based imminent threat perception. Right. Let's have a mains question. Preemptive self-defense challenges the traditional understanding of the sovereignty and non-aggression in international law. Discuss the context of recent geopolitical developments. So you have to maintain that. What do you mean by preemptive self-defense? Okay, so maybe it is invoking self-defense against perceived imminent threat which may not exist in reality. It may be because of the miscalculation. So that means it will reduce the issues with respect to the understanding of sovereignty and non-aggression, because even if there is a non-aggression, you may strike based on the preemptive manifestations or preemptive calculations. All right, there's a debate happening, and what is the implication? Erosion of the international norms, escalation of the conflicts, and disputed legitimacy. Right. Now, US Supreme Court curbs Trump's emergency tariff power. The US court with a 6-3 ruling has struck down President Trump's tariff imposed under the International Emergency Economic Powers Act 1977. The judgment reinforced the constitutional limits on executive powers and has wide implication for global trade, including India. Right. So issue was executive versus legislative authority. Congressional power over tariffs. The US Constitution grants Congress the authority to vest tariffs and taxes. All right. The court ruled that using IEEPA to impose sweeping tariffs exceed presidential authority. Right. So it is primarily used for sanctions and asset freezes, does not explicitly authorize tariffs. Trump is the first president who used it for invoking broad tariff impositions. What is the challenges and way forward? Ongoing executive legislative tensions over trade authority and risk of protectionism through alternative legal provisions. Let's see what is the Trump's strategic tariff strategy. He is using trade as an economic and foreign policy tool. Liberation Day tariffs in 2025, reciprocal tariffs were justified under a declared national emergency linked to trade deficit, fentanyl trafficking and migration concern. Alternative tariff mechanism after the judgment. What he is doing, he is now using Trade Act 1974, which allows temporary tariffs up to 150 days up to 15%. Trade Act 1974 also allowed targeted tariffs after investigation of unfair trade practices, previously used against India's digital service tax as well. Also, the Trade Expansion Act 1962 permits sector-specific tariffs in national security grounds. So now they will be using these of the act to promote tariffs after the Supreme Court judgment. Right, let's have a prelims question. In the United States, Congress has primarily authority over trade and tariffs. The executive exercises tariff power without any restrictions. This is an incorrect statement. Judicial review can examine executive actions related to the trade policy. This is a correct statement. Answer would be 1. Now, mains, let's see. What introduces frictions into the ties between India and the US? In what Washington is still unable to find for India a position in its global strategy? What would satisfy India's national self-esteem and ambition? Explain with suitable examples. So this is again the trade. You can use that what is causing US that it is not able to find a position for India in its global strategy. So you can mention the recent trade and tariffs over India as well. Now let's have a mains question. Discuss how the use of unilateral trade measures by the United States affect the India's trade policy and strategic autonomy. So you can mention the unilateral trade measures, and also, for example, you cannot buy the oil from different countries and the trade sanctions. This is India affecting India's trade policy and strategic autonomy, trade uncertainty, strategic constraint, leverage tariff to pressure India into concession in trade talks, potentially undermine India's strategic autonomy in policy making. Diversification of partnerships is required that you can use as a way forward. All right, Myanmar elections 2026. The recent elections in Myanmar have brought the military-backed Union Solidarity and Development Party to power with a landslide victory, closing the political cycle that began in the February with the military coup. The outcome raised certain concern for India amid Myanmar's continuing instability. What are the issues? First, the elections are unlikely to mark the end of the coup and instead represent an effort by the military regime to normalize and legitimize its post-coup rule. Second, India's strategic security concern. First of all, border instability. India shares 1,643 kilometers porous border with India, Myanmar, which is vulnerable for spillover effect. Rebel and ethnic militias reportedly control over 42% of the Myanmar's territory. That is also there. Some around 30,000 refugees in Mizoram from Myanmar still in India. Sharp rise in cross-border arms trafficking and synthetic drugs seizure, a major worry for India. Infrastructure risk, for example, Kaladan multi-modal project, India-Myanmar, Thailand trilateral highway, and risk of delays or disruptions due to the instability. Now let's have a prelims question for you. With reference to the Myanmar and its geopolitical significance, consider the following statement. Myanmar acts as a land bridge between South Asia and Southeast Asia, making it critical for India's Act East policy. Principle of non-interference has limited its ability to effect address of Myanmar's internal politics crisis. India's engagement with Myanmar is guided by democratic concerns with no strategic or security consideration. This is an incorrect statement because we have this security concerns as well. So answer would be 1 and 2 only. Okay. Now, analyze the internal security threats, the trans-border crimes along with Myanmar, Bangladesh and Pakistan, including line of control. Also discuss the role played by the various security forces in this regard. This was asked by the UPSC. Okay. So how you can answer internal security threats? You can mention with respect to, for example, we have this porous border, militias, okay, refugee crisis, arms trafficking and synthetic drugs you can use. Now, instability in Myanmar has transformed from a domestic political issue into a regional security concern for India. Examine the context of border management, insurgency and connectivity project. You have to mention the border management, insurgency and also the infrastructure risk. You can take hint from these parts also. Okay, so we have given it over here as well. Now, opening of the European Legal Gateway Office in India. So basically, EU and India marked a significant step in strengthening mobility cooperation with the launch of the European Legal Gateway Office in New Delhi. It follows a signing of comprehensive framework for cooperation on mobility. How it will help? It will facilitate safe, legal and well-informed migration from India to EU member states. With the focus primarily on ICT, it will support India's student, research and professionals. Strategic importance for India. India as a global talent hub. Also strengthening bilateral ties. It will promote people-to-people contact. Also broader implication reflect as an emerging global workforce model. Encourages legality, transparency and fairness in talent flows. All right. So let's have a prelims probable question for you. Consider the following statements. The initiative aims to assist businesses in navigating regulatory frameworks. It is primarily focused on defense cooperation, which is incorrect. It reflects increasing regulatory and economic engagement between India and EU. The answer would be 1 and 3 only. Prime Minister Modi held bilateral talks with his counterpart in New Delhi, where both countries strengthened defense and maritime cooperation and adopted new joint vision framework. Okay, the visit coincided with the 50th anniversary of Seychelles' independence and 50 years of diplomatic relations with India. During the visit, 7 MOUs were signed, including pharma cooperation, meteorological collaboration, and cultural exchange programs. Okay, so what are the key highlights of the India-Seychelles partnership? If I tell you, elevation of India, adoption of joint vision, which both countries adopted the joint vision for sustainability, economic growth, security through enhanced linkages, emphasis on sustainability, security and economic cooperation. Shared maritime and democratic values, reaffirmed partnership rooted in history, kinship and democratic principles, expanding cooperation in new areas, for example, renewable energy, marine research and digital and capacity building initiatives. Also defense and maritime cooperation. Colombo Security Conclave membership, Seychelles welcomed as a full-time member in the recently held Colombo Security Conclave as well. A special economic package for the Seychelles is India is also giving these things. Strategic significance, if I mention, Indian Ocean regional stability reinforces India's vision Mahasagar, that is mutual and holistic advancement for security and growth across region. It also enhances peace and stability in the Western Indian Ocean. People-centric and economic ties, global tourism cooperation highlighted as a key economic pillar for the Seychelles. Growing Indian tourist presence supported by the improved air connectivity as well. Conclusion, as strategic maritime neighbor, both nations aims to strengthen regional stability and build a shared future in Indian Ocean region, which is in sync with the Indian policy of Mahasagar. We have a question from you. Seychelles is a strategically located in Western Indian Ocean. Okay, it plays a role in India's Sagar security vision. Seychelles is a member of Quad, which is an incorrect statement. Answer would be 1 and 2 only. Right. Now, India is an old age friend of Sri Lanka. Such sort of questions are there in the UPSC exam. On that basis, we have a mains question for you. Small island states are central to India's maritime strategy. Discuss with reference to the Seychelles. Okay. So, small island states, why they are important? Because first of all, they are your maritime neighbor. Also, they promote stability and security. This is also in sync with the Mahasagar doctrine of India. Alright, so you can mention security in the Indian Ocean region also, and defense and maritime cooperations, which we have also mentioned over here. Right, you can pick it, the hint from here and try to write this answer. Next topic that we'll be discussing is science and technology. First is the Bharat Gen AI. So recently, Ministry of Science and Technology informed that this Bharat Gen AI large language model will complete the text in all 22 scheduled languages by February. What is this? This is the first government-supported initiative to build sovereign foundational AI models, which is very, very important for India. For Indian languages and context developed under the National Mission on Interdisciplinary Cyber Physical STEMs, implemented through TIH Foundation's IIT Bombay. Objective is to revolutionize AI development. Alright, key features multimodal AI, that means it has text, speeches, and as well as visual language systems as well. Multilingual, supports 15 languages, expanding to 22 languages soon. 4 pillars, it has technology, development, entrepreneurship, human resource development, and international collaboration. Bharatiya Dataset Training. That is, the training is driven by the indigenous data-driven models. Open source orientation to promote collaboration in ecosystem. Indigenous generative AI RD ecosystem. Strengthen AI sovereignty and innovation capacity. So this is about the Bharat Gen AI. Now, development of artificial intelligence is a prominent theme in exam. We have a prelims question for you. Bharat Gen AI aims to develop indigenous AI models tailored to Indian languages. This is a correct statement. It focuses exclusively on defense application. It is not. It is working on technological development, entrepreneurship, human resource development, international collaboration. It aligned with India's digital public infrastructure approach. Yes, it is an open source orientation based on the Indian dataset training. It will promote Indian digital infrastructure push. So answer would be 1 and 3 only. Right. Now, how science is interwoven deeply into our lives? What are the striking change in the agriculture triggered by the science-based technologies was asked by UPSC. Similarly, how science is interwoven deeply in our life is now new term that is emerging is AI. On that basis, we have a mains question for you. Discuss the significance of indigenous AI ecosystem like Bharat Gen AI in ensuring technological sovereignty. So technological sovereignty how? Because first of all, it is built sovereign foundation AI model. Second, it is based on the Bharati dataset training. It is multilingual for Indian languages. It is also a multimodal. It will promote 4 pillars and it will promote also international collaboration. So you can take hints. It is also prevention of linguistic and cultural identity, economic resilience, foundation AI model in all 22 scheduled languages, technological sovereignty. So on that basis, you can mention this answer. Model Context Protocol. Recently, National Stats Office under Ministry of Stats and Program Implementation launched a beta version of its Model Context Protocol server for e-Sankhiki portal. First of all, you have to important is what is e-Sankhiki portal. Now, what is the protocol? Protocol is a rules that govern data communication. All right. So it is a standard protocol that enables large language models, AI agents to directly access dataset tools and workflows to ensure structured real-time information access for its execution. For example, you have had a query with a large language model, so that model will immediately real-time basis, it will be having to access to the datasets. That all will be done with a protocol. That protocol is known as Model Context Protocol. All right, users could be planners, policymakers, researchers, and also the public. It has 2 models. First is data catalog model, centralized repository of major Ministry of States and Program Implementation dataset, and also macro indicator module provides time series macro data with filtering, visualization, custom downloads, and API access. Okay, so based on that, you please remember what is e-Sankhiki portal, which is recently in the news. It is launched by the Ministry of Electronics and IT. No, it was launched by Ministry of Statistics and Program Implementation. It serves as a centralized platform for dissemination of official status. That is the correct statement. It means only for government officials and not for the public. That is an incorrect statement. Public is given over here. Answer would be 2 only. Now, graphics processing unit. Again, India and United States have announced that they will significantly increase trade in technologies products, including GPUs and other goods used in data centers. What is a GPU? Basically, it's a specialized processor for high-speed parallel computation. Parallel means they will be able to work on multiple threads in one go to increase the speed of your computation speed of your computer. Okay, initially developed for 3D graphics rendering, it works alongside CPU. Okay, where CPU is important, it will direct operations. There are 2 types. First is discrete, which is on a separate add-on GPU, which is generally found in the desktop models. Then you have an integrated one, which is installed on the same chip with that of CPU. It is generally on your Palm and laptops. Right. Key features: parallel processing architecture. Multiple cores means there is a process. Process will have multiple cores, and each core will be taking up a thread. And with this thread, they will having multiple tasks in one go. More than one task would be taking place at one time, optimized for intensive computational task. Uses almost all possible uses, for example, AI, machine learning, deep learning, high performance computing, weather, climate modeling, cryptocurrency, mining, and data centers. Okay, now consider the following statements. GPU are optimized for parallel processing. Yes, they are critical for AI and machine learning, correct. They are primarily used for sequential data processing. Sequential data processing is slow. They are used for parallel data processing. This is an incorrect statement. Answer would be 1 and 2 only. Mons Mountain. So scientists from ISRO has identified a landing zone in rugged South Pole region of the moon called Mons Mountain for India's lunar sample return mission Chandrayaan 4. You know, in Chandrayaan 3, you have successfully have a soft landing on the southern pole of the moon. Now in Chandrayaan 4, the mission is that you will land and also get some sample back to the earth, and the landing zone is this Mons Morton. Okay, so it is basically a 6-kilometer high temperature near the high hill mountain near the moon's south pole. It is located on the rim of the South Pole Aitken Basin, which is largest and oldest lunar impact basin. It is named after NASA mathematician Melba Roy Morton. What is important? First, it is relatively flat summit, so easy for have the landing, receive extended sunlight, so favorable for the solar powered missions, maintain line of sight communication with the earth. So it is all checkboxes tick. Significance: not nearly permanently shadowed craters with potential water ice deposit. Crucial for studying lunar geology, evolution and in situ resource utilization. Strategic site for future exploration and missions. Right. So it was asked, for example, whose name based on Chandra X was named as. Similarly, Mons Morton recently seen in the news is related to what? Deep sea ecosystems, lunar surface features, atmospheric chemistry and genetic modification. Answer would be B, lunar surface structures. Right. Now next important mission is Biopharma Shakti. Very important thing for your exam. Recently, Union Minister of Finance has announced this launch of Biopharma Shakti initiative in budget 2026 and 27. What is Biopharma Shakti scheme? It is a 10,000 crore 5-year national initiatives aimed at strengthening India's end-to-end ecosystem for biologics and biosimilar production. It is strategic shift from India's traditional strength from generic medicine to becoming a global hub for highly valuable biopharmaceuticals, targeting 5% of the share in global biopharma market. Now, what is this? We know India is a hub of generic medicines, right? That is why it is known as the pharmacy of the world. Now India is advancing its manufacturing and research capability so that they will be developing biosimilars and also biologics. All right, with this they will be targeting the global trade, and they try to have a target of at least 5 trillion, 5% of this share in the global trade market, right? Now, what is biologics? So, biologics are basically very complex medicines made from living cells, organisms whose difficult manufacturing. It is very, very difficult to manufacture, and that is why there is a limiting only to the high income countries. Same like the medicines, and to that solution, India came up with the generic medicines. To this solution, India came up with the biosimilars. Similarly, biosimilars are the similar version of the biological medicines that match the biologics in safety and effectiveness, offering affordable alternatives and increasing competition. Right now, India will be working on these two as well. Build so that it will reduce the import dependence in high value biologics, build domestic capabilities of research, manufacturing and regulations, global biological supply chain to be part of, increase access to advanced and affordable biological therapies, position India as a preferred global clinical research destination. Key features is again manufacturing strengthening, all right, human resource development. So for that, they have 3 new National Institute of Pharmaceutical Education has promoted clinical research ecosystem, 1,000 plus accredited clinical trial sites, regulatory clinical buildings, strengthening of Central Drug Standard Control Organization, faster evaluation of complex biologics, and alignment with global regulatory standards. This is all there. What is the significance? If I ask, strategic healthcare security, move up in the value chain from the generic drugs to the biosimilars and biologics. Economic and export potentials, it will about $1+ trillion, right? That would India will claim. Innovation boost, it will in sync with the National Biopharma Mission, Bio-E3 policy and PRIP schemes. However, there are some challenges. First is again very high capital intensity, regulatory complexity, skill gaps, and also coordination issues, clinical and trial ethics and trust deficits, and also the global competition. So these things have to be taken care of if India really want to reap the benefits of this Biopharma Shakti scheme. However, it's a good move. Let's have a PYQ. Biofilms, there was a PYQ on that. So this time we have biologics and biosimilar in the news. The prelims question. With reference to Biopharma Shakti, consider the following statement. It aims to strengthen India's end-to-end biopharmaceutical ecosystem, including research, manufacturing and regulatory capacity. This is a correct statement. It promotes indigenous development of biologics and complex therapeutics to reduce import dependence. It focused exclusively on public sector enterprises to build strategic capacities. This is an incorrect statement. They will promote private investment as well. It aligns with India's broader objective of achieving self-reliance in critical healthcare technologies. That is correct. Answer would be 1, 2 and 4 only. Right. Now, mains introduce the concept of artificial intelligence. How does AI help clinical diagnosis? Now, biopharma is in news for the same purpose. So we have a mains question for you. Evaluate the role of initiatives like Biopharma Shakti in enhancing India's healthcare resilience. You have to mention what is Biopharma Shakti scheme, what are the objectives, what are the key features. For example, manufacturing, strengthening, human resource development, clinical research ecosystem. You have to mention some of the challenges and then you have to give a conclusion remark that how these challenges could be resolved. Okay. Then the Maltbook platform. A new tech platform called Maltbook has erupted across social media as the first social media network designed for AI, exclusively for AI agents. What is this? It is an online machine-to-machine social platform, right, where artificial intelligence can interact autonomously without direct human interventions and for each exchange. Okay, this is it is basically based on autonomous instructions. AI agents, they post, they reply, and they upvote in threaded discussion that you do on the Quora. Interactions occurs via UPIs, other ones connected by the human owners. That means once you are needed to connect it with that, after that the process is autonomous. These chat agents will be communicating by their own. Machine-centric discussion range from technical issues to abstract themes like identity consciousness. Text is generated from training data plus ongoing interactions. Emergent behavior. Agents adapt responses based on interactions, remix ideas, and create debate like evolving threats. Significance, it illustrates AI to AI communication ecosystem and raises governance, autonomy, and digital ethics questions. Okay, so let's see. Platforms question was asked previously by UPSC. Now we have the Maltbook platform recently seen in the news is related to the machine-to-machine social platform. All right. Now let's have the myoglobin. Researchers have developed a flexible, low-cost biosensor capable of detecting myoglobin, which is associated with the early state of heart attack. Okay, so there's a biosensor which will detect the myoglobin, which is the early state of heart attack. So it is a small oxygen binding protein found in skeletal and cardiac muscle. It is some around 2% of muscle protein. It has one polypeptide chain, right? It stores and releases oxygen in muscles during high demand. When there is a high demand, means there is some pressure situation, it will start releasing oxygen. This also helps in regulating mitochondrial respirations. Now we have a low-cost biosensor. So with this biosensor, we will sense easily when the myoglobin is starting releasing oxygen. That means this heart is in stress, and earlier steps would be taken to reduce or to protect from the heart attack or the cardiac arrest. All right. Please remember, unlike hemoglobin, which has 4 oxygen sites, myoglobin has only 1 O2 binding site. Right. Now next is prelims question. Myoglobin stores oxygen in muscle cells. It's structurally similar to that of hemoglobin. Right. It transports carbon dioxide in the blood. This is an incorrect statement. Okay. So answer would be 1 and 2 only. India AI stack. It is an integrated national AI ecosystem designed to enable AI deployment at population level. That means they want to large scale the development of AI with the vision of democratization of AI. That means AI should be available to everyone. It is not limited to only big manufacturers or the big companies. All right. It integrates infrastructure, models, compute, data, and applications to turn data plus compute into a real world impact. So basically it will have 4 layers. First is application layer that is visible to the user. For example, for the solution in agriculture, healthcare, education, justice, disaster management, etc. AI model layer, it is indigenous and sovereign AI models. For example, India AI Mission, Bharatjan and Bhashini. Compute layer, subsidized GPUs, tensor processing unit, access via India AI compute portal. Data and network infrastructure layer, data centers, optical fiber and 5G infrastructure would be provided. Energy layer, reliable and increasingly clean energy to power AI infrastructure. Basically, they will be providing as infrastructure as a service, software as a service. Okay, so that you can use the AI stocks. It is for the democratization. That means it is available for all, not limited to the few one who can avail. Need to democratize AI access beyond large corporations, to reduce dependence on foreign AI ecosystem, enable AI integration in public service delivery, and also to support India-specific multilingual use cases, not limited to few languages. Significance, promote AI for humanity approach, which is India's stand. Strengthen technological self-reliance, that is AI sovereignty. Boost startups, innovation and semiconductor ecosystem. Aligns AI growth with clean energy and sustainability goal. Okay, so on that we have a prelims question for you. With reference to the India AI stack, consider the following statements. It aims to build a unified digital infrastructure to enable scalable deployment of AI solutions across sectors. Okay, It seeks to leverage existing digital public infrastructure such as Aadhaar, UPI, and digital locker. This is not mentioned over there, but this will use the AI model layers for the data. Okay, so it is designed exclusively for government use and strict participation of private sector entities. This is an incorrect statement because it promotes for the population level democratization of AI. It is not just for government entities. This is an incorrect statement. It facilitates access to the dataset, compute capacity, and tools for AI development. This is a correct statement. So answer would be 1, 2, and 4 only. Now, SphereX mission. NASA's SphereX mission turned into infrared gaze on interstellar comet AI, which is known as Atlas. Recently, adding to the deep pool of information agency has gathered on what is only the third such object to be discovered passing through our solar system. Right. So first of all, you please remember this comet Atlas. What is a SphereX mission? So it is a basically mission for space telescope mission launched in 2025 to conduct the first all sky spectral survey optical to near infrared wavelengths. Right. Objective is to create a 3D map of the universe to study cosmic inflation, also galaxy evolution and distribution of the water and organic molecules in the space. This is the objective of SpaceX mission. Right. So it will survey some around 400 million galaxies and also some 100 million stars in the Milky Way. Right. Consider regarding the SpaceX mission, it is a space telescope mission designed to conduct an all-sky survey of the optical and near-infrared wavelength. Correct. It aims to study the origin of the universe, including cosmic inflation, galaxy formation. Correct. It will map the distribution of the water and organic molecules on the Milky Way. It is a joint mission of NASA and European Space Agency. This is an incorrect statement because it's a mission of NASA. Okay. Answer would be 1, 2, and 3 only. Now, Copernicus Sentinel-2 mission. This is a mission of European Space Agency, okay, which has released a stunning high-resolution images of 2026 Winter Olympic venues across North Italy. Now, what is this all about? So, it is a developed Earth observation mission under the EU Copernicus program for monitoring land surface changes. Right. So, basically, it has a twin satellites, Sentinel-2A, Sentinel-2B, with a sun-synchronous polar orbit, providing 5-day global revisit to 90 km swath. Technological features deliver high-resolution multispectral images in 13 bands, that is visible light, near-infrared, short-wave infrared. Applications are very wide. Used for agriculture, food security, ecosystem, land use monitoring, disaster management, water quality and methane emission tracking as well. Okay, so this is about the Copernicus Sentinel-2 mission. It is a program of European Space Agencies under a space program led by the European Commission in partnership with the ESA. It integrates data from Sentinel satellites and into ground to provide free, open and near real-time information for the environmental and security monitoring, because it will also give you pictures relating to the surface change on the Earth. Okay, let's see question. Copernicus Sentinel-2 mission consider the following statement. It is a part of European Union's Earth observation program aimed at environmental and land monitoring. This is a correct statement. It provides multi-spectral optical imagery useful for agriculture, forestry and disaster management. It operates primarily in microwave frequencies, enabling all weather and day-night imaging capacity. It accepts not in just microwave but in the 13 bands, which is visible, near infrared, short wave infrared. So this is an incorrect statement. Data from Sentinel-2 is openly accessible, supporting global scientific and policy intervention. This is given over here, right? So answer would be 1, 2 and 4. Next is we have this Sarvam AI. As the name suggests, Union Minister of Home Affairs stated that why the future belongs to India when it comes to AI. It is a made in India full stack AI company which is developing sovereign multilingual foundation models aligned with the India's public service and governance need. Institutional support, it is selective under the Innovation Center pillar of the Indian AI mission to develop indigenous functional model of the AI with the support of 246 crore rupees. Core focus, they want to promote a large language model which is indigenous in nature, which is trained on the Indian language and Indian data set, reduces dependence on the foreign AI ecosystem. Key products, it has product Bulbul. Bulbul is a text-to-speech in the 11 languages. Also, it has a Saras, which is a speech-to-text, which in the all 22 scheduled languages has been done. Okay, so with this is Sarvam AI, which is promoting indigenous AI model on the indigenous languages only. Okay, it focuses on developing large language model optimized for Indian languages and context, which is a correct statement. Like it aims to enhance accessibility and inclusivity in AI by supporting devices like linguistic ecosystems in India. Okay, it aims to enhance accessibility and inclusivity in AI by supporting diverse linguistic ecosystem in India. This is also a correct statement. Answer would be 1 and 2, both. Now, Zeigarnik effect. This is something very interesting. It's a psychological phenomena where unfinished or interrupted tasks are remembered better than the completed one. It is proposed by the Bluma-Zeigarnik based on the observation by the Kurt Lewin. Why it happens is because starting a task creates a mental tension. If it is incomplete, it remains in the open loop in short-term memory. This causes cognitive tension, which makes it difficult to forget. It is very important in learning and productivity, right? So the term Zeigarnik effect is recently seen in the news as related to the phenomena where unfinished or uninterrupted tasks are better remembered than complicated tasks. Okay. Now next we have is the National Biobank for Lysosomal Storage Disorders. Something very important. Researchers has compiled a first government-supported national biobank for rare diseases called lysosomal storage disorders. What is this? It's a group of 70 plus rare inherited metabolic disorders caused by deficiency of lysosomal enzyme in the body, which is life-threatening and mostly affects children. Issue is that India have over 12,000 estimated LSD patients. In a cohort, 530 cases which were reported 2008 to 2025, 60% have died and only 8 received the treatment. This is the gravity of the problem, and therapies exist for just 7% rare diseases and cost over 1 crore per patient annually, limiting its accessibility, right? So now what is about this LSD biobank? India's first government-supported biobank led by the Foundation of Research in Genetics and Endocrinology and funded by the Department of Biotechnology. It was published by Orphanet Journal of the Rare Diseases. So multiple institutes are involved in this. How they are working on? Institute of Stem Cell Science and Regenerative Medicines. It is working on general therapeutic approaches so that the therapies should be given, because I have just mentioned only 7% for the 7% of the diseases therapies exist only. Center of DNA fingerprinting and diagnostic, developing screening technologies using spectrometry so that we can get an early signals. Collaboration with the Tata Institute of Genetics and Society, developing stem cell based disease models so that in case it is possible, we can work on the cure of these devices. Okay, significance: first centralized clinical genomic registry in LSDs in India. It enables early diagnosis, screening technologies, affordable indigenous therapies and stem cell disease models. It reduces dependence on costly imported therapies and strengthens India's rare disease reach out ecosystem, which is very, very important because you can see the data. Okay, so Wolbachia method was asked previously. We have this prelims probable question for you. Now, the National Biobank for Lysosomal Disorders, recently seen in the news, is primarily intended to facilitate storage of agriculture genetic resources for improving crop resilience. Incorrect. Create a centralized repository for biological samples to support research, diagnosis, and treatment of the rare genetic disorders would be the right answer. Okay, now we have the mains question for you. Biological data is a new frontier of public health governance. Analyze this statement in the context of biobanks and genomics research in India. So you can mention that this is the situation, and with this biobanks, which is there, we can help developing maybe a therapeutic. We can have this solutions, developing screen technologies using spectrometers, and also stem cell based disease models could be promoted, could be developed with based on these biosensors and biological data. Okay, that is how you can write this answer. Now, characterizing exoplanet satellites. European Space Agencies just revealed a 4-planet system where outermost world is a small and rocky planet, not a gas giant. What is this all about? This is the first space mission dedicated to precise study of known exoplanets orbiting brightly nearby stars. Okay, it was launched in 2019, sun-synchronous dusk-dawn orbit, some around 700 kilometers of altitude. Objective is to measure planetary radii with high precision by observing transits which is passing through the host star. Focus: Super Earth to Neptune-sized exoplanets they will be targeting on. Instrument are high precision, photometer is there in this. It measures planet diameters, some around 10% of the accuracy. When combined with ground-based mass data, it enables calculation of the planetary density. Density helps determine cosmoposition, rocky, gaseous or water-rich ocean worlds. This will further promote your study related to the whether life is possible on other planets or not. So, with reference to the CHEPOS mission recently seen in the news currently consider the following statement. It is a mission of JAXA aimed at studying known exoplanets. This is incorrect. This is a mission of ESA. It focuses on determining the size and density of the exoplanets by observing their transits. It primarily designed to discover new exoplanets. No, this is not new. This is for the known exoplanets basically. Okay, so this is an incorrect statement. Answer would be 2 only. Quorum sensing. The phenomena of bacterial communication or quorum sensing. Basically, understand quorum sequencing is something through which bacteria communicate with one another. Okay, so they send a signal. Once number of bacteria are very high, the strength of the signal would be high, and then there will be communication, right? This is called quorum sensing. It would be helpful in therapies and antibiotics prevention. How? It is a mechanism by which bacteria regulate gene expression in accordance with the population density through the use of signal molecules. Okay, so auto-inducers accumulate, then once threshold is received, they will activation of specific genes. First is virulence, that means this become harmful now. Okay, that means number of bacteria has increased so much that they become harmful. Biofilm formulation, that means they create a protective layer. DNA uptake, they will have some gene editing with respect to the atmosphere. Horizontal gene transferring of the useful genes, and also symbiosis with the host in order to perpetuate. So this is the situation. So with this quorum sensing, once we sense that okay, the threshold is about to achieve, the scientist will now try to cut down this communication. Okay, so that means the signal will become weak and the bacteria will remain weak. They will not harm the human health. So this is a better solution than giving the antibiotics, because we know India is facing the issue of AMR, right? So in this background, this is important. With reference to the quorum sensing, consider the following statement. It is a mechanism by which bacteria communicates using chemical signaling molecules. This is a correct statement. It regulates gene expression in response to the changes in population density. It plays a role in process such as biofilms formation and virulence. This is a correct statement. Answer would be 1, 2, and 3. Now, bio-based chemicals. Bio-based chemicals are, what are they? They are basically industrial chemicals made from renewable biomass, for example, agriculture waste. Okay, through biological processes like fermentation, they are useful in cosmetics, plastic, and pharmaceuticals. Why India is doing that? Because first of all, we have the leverage strength. India has a large agri base. We have a pharma grade fermentation expertise and strong manufacturing ecosystem. So India can go and capture the market. Reduce import dependence on petrochemicals, because petrochemicals, India has imported acetic acid around some 480 millions. So this is a bio-based chemicals is a substitute of petrochemicals. Create value-added materials for agriculture produce. Position India as a global supplier of sustainable industrial inputs. That is why India is pushing towards the bio-based chemicals. Now, what is the situation currently? India has prioritized bio-based chemicals and enzymes under the Department of Biology Bio E3 policy. Right. However, there are some risks associated with this approach. First is cost disadvantage. Bio-based products are often costlier than petrochemical alternatives in early stages, which will deter private investment. Then we have feedstock and infrastructure gap. Uncertain biomass supply and limited large-scale biomanufacturing facilities constrain scalability. Market adoption risk. Substitutability in existing manufacturing chains and willingness of the downstream firms to switch remains uncertain. Then what needs to be done? India should start scaling shared infrastructure so that the initial capital cost will come down. Right. So assume this is a prelims question. With reference to the bio-based chemicals recently seen in the news, consider the following statements. They are derived wholly or partially from renewable biological resources such as biomass. Their use can contribute to reducing dependence on the fossil fuel-based feedstock. All bio-based chemicals are inherently biodegradable and environmentally benign. This is an incorrect statement. They can be used in sectors such as packaging, pharmaceutical, and energy. This is correct statement. Answer would be 1, 2, and 4 only. Now we have SAHI and both initiatives for the Ministry of Health. So basically, this is a strategy for artificial intelligence in healthcare for India, which is known as SAHI. Benchmarking open data platform for AI health is both. So basically, it's a national framework to ensure safe, ethical, evidence-based, inclusive use of AI in India's healthcare system. Okay, it serves as a policy compass to guide a responsible AI integration, helps in states adopt AI. For example, state wants to adopt an AI in healthcare. They must ensure that their policy is in sync with SAHI. That means correct. Okay, both is basically is developed by IIT Kanpur. It is basically the National Health Authority's a privacy-preserving benchmarking platform that evaluates AI model on real-world health data without sharing data set. Okay, so it will ensure your privacy. It will not share data set. It will check it is basically like a testing tool for the AI model. Okay, so together they strengthen responsible and globally competitive AI health adoption in India. Let's have a prelims question with reference to Sahi and both initiatives recently seen in the news. Consider the following statements. They are aimed at integrating artificial intelligence into the education ecosystem. They support data-driven and adaptive learning approaches. Both of them are correct. Answer would be 1 and 2, both. Okay, the next is Voice Era. What is this? The Digital India Bhashini division recently launched Voice Era, an open source end-to-end voice AI stock. It is basically a tool through which the Indian citizens or maybe the other people later on can use AI through voice command. Basically, understand it in simple terms. It is basically that when you are speaking to an AI agent, you can take the help of this. You can use that AI agent, that is the Voice Era. So Bhashini is basically India's digital public infrastructure for languages launched by the Ministry of Electronics. Objective is to create a national multilingual voice execution layer over the Bhashini, right? So expands Bhashini from translation to the full voice AI ecosystem, enables voice-based citizen services, agriculture, education, and grievances. Okay, it strengthens sovereign and inclusive AI infrastructure. So basically, we know because the digital literacy is not very high in India. So if this AI would remain only based on the commands in the text, it would not, majority of the people may not be able to utilize the AI. Hence, Bhashini is promoting this voice era. That means through the voice command only, you can use the AI, same that you use your mobile through your voice commands in current days. Okay. So then we have the tetrodotoxin. It is basically a natural poison found in the seafood, basically puffer fish. Okay, so this is basically a natural poison. What happened recently? Food safety authorities and doctors suspect that there is severe illness in people who consumed seafood at a restaurant in Kerala was caused by the contamination with a highly potent marine neurotoxin, likely tetrodotoxin. Okay, so that was that. It is an extremely potent marine neurotoxin, basically a natural poison. Mode of action: blocks nerve signal transformation, led to muscle paralysis. It is 1000 times more toxic than sodium cyanide. You can imagine. It can be fatal if there is no antidote, supportive treatment only. It is generally found in puffer fish, porcupine fish, ocean sunfish. Okay. So with reference to the tetrodotoxin recently seen in the news, consider the following statements. It is a potent neurotoxin that blocks sodium ion channels in the nerve cells. It is commonly found in certain marine organisms such as puffer fish. So answer would be 1 and 2, both. Now, Yuva AI initiatives. Basically, again, Ministry of Electronics has launched Kaushal Rath under the National AI Literacy Program, Yuva AI for All. So basically, what is this? These are the mobile. Okay, so this is the mobile, basically mobile computer labs, which has all the internet-enabled system, audio-visual tools, and structured training programs. With these mobile vans, they will be getting to the schools, maybe the colleges, schools, and everywhere where people, students, and the teachers, they can have like hands-on experience on the AI. Okay, so this is the objective launched by MEDI under the National India Mission. Objective: AI literacy for 1 crore citizens. Course features: it is free, self-paced foundation AI courses, India-centric practical exams, and also available on Future Skills, Prime and iGot, Karmayogi. Government of India will give a certification once the course is complete. Okay, so basically this is an internet-enabled system, audiovisual tools, and structured training modules. It will travel to school, colleges, ITIs, and community centers to deliver hand-on exposure to the AI generative tools, supported by the trained facilitators and contextualized Indian use cases. Okay, so there will be mobile, means for one season there will be in one school, second time there will be in another school, so that the infrastructure could be shared. The Yuva AI for All initiative recently seen in the news. What is best described as? The program is developed advanced AI models for defense applications, not for defense. It initiative to promote AI literacy and skills among school students and inclusive manner. This is a correct statement. Wet dead dress rehearsal. Basically, it is the final testing before launching of a rocket. That is known as wet dress rehearsal. So recently, NASA found a hydrogen leak during a wet dress rehearsal of Artemis 2 mission. Okay, so what do you mean by it's a final full stage practice before a rocket launch involving actual loading of cryogenic fuel, which is a very low temperature actually. Okay, which is generally liquid oxygen or liquid hydrogen. So process is that first of all they'll go for fuel line cooling, propellant loading, pressurization, leak checks, and also full countdown in order to check if there are any sort of errors before the final launch of the rockets. Alright, so it will test rockets, ground system, system integration, reveals leaks or faults under cryogenic conditions, ensures launch day readiness. Okay, so this is the known as dry day rehearsal. The term wet dress rehearsal, frequently seen in the context is space mission, refers to a full-scale rehearsal of a launch sequence including fueling and countdown procedures. This is important. However, a dress day rehearsal is known as a launch countdown simulation conducted without loading cryogenic propellants. The team powers up vehicle and ground system, test communication. That means the cryogenic fuel is the difference between dry day and wet day preparation. Right? So this is the difference between the two. Exposum. So basically scientists are launching an ambitious global effort to map the human exposum. That means a lifelong mix of environmental, social, chemical exposure that drives most diseases. Alright. So what is exposum? It is a total lifetime exposure of an individual and its impact on health. It is defined by International Human Exposure Network as an integrated set of physical, chemical, biological and psychological factors and their interactions. Internal, it is metabolism, microbiome and hormones, inflammations. External could be pollution, chemicals, diet, lifestyle and social factors. Significance is that it will explain environmental contribution to diseases, also support preventive and precision medicine. Further research is pending, so just recall this. Now, Panama disease. Recently, scientists discovered a gene that could save bananas from deadly Panama disease. Okay, what is this? This is basically a fungus disease. Okay, this is a fungal infection into the banana trees, especially highly destructive banana disease. Fungus survives in soils for a year. So basically, it enters through roots and then blocks vascular tissues, cuts supply of the nutrients and water. Finally, this will lead to the dry of the plant. It is also known as the banana cancer. Okay, now they have discovered a gene that could save banana from the deadly Panama disease. Okay, in this context, UPSC has asked about the hereditary diseases. You please have a prelims PYQ. What the term Panama disease, frequently seen in the news, refers to. It is a fungal disease affecting banana plants, causing wilting and crop destruction. Okay, now lenacapavir. Recently, Zimbabwe has begun rolling off this lenacapavir along injecting HIV preventive medicine. Okay, very, very important. So basically, it's a long-acting injectable HIV vaccine. You have to take like once every 6 months. That means twice a year. Clinical trial shows 99% risk reduction in the high-risk groups. Okay, significance is that it improves adherence versus daily oral PrEP. Major advances in global HIV prevention strategy, right? Because consuming a daily oral is a difficult thing. This is just for twice a year. Okay, improves adherence. Capsid. It is basically have a covered layer over the capsid. Capsid is a protein shell of the virus that encloses and protects its genetic material. Okay, so it's a protective layer. Basically, when you give a vaccine would not help, will not be acting on the genetic material because there is a layer. This will reduce the capsid if the virus needs to get out of this lenacapavir, it has to break down its capsid, and when these vaccines will be acting on these viruses. Okay, this will reduce the I would say duplication of the virus also, right? It is made up of repeating proteins unit called capsomeres, lies beneath the viral envelope, protecting and delivering viral DNA RNA into the host cell. A new study recently found that in escape the drug lenacapavir, HIV must damage its own capsid. Okay, reaffirming that the viral capsid is an effective target for antiviral therapy, right? So that was there in the news. Vicosat 1. Okay, now 13 students from class 11th from a school in Tamil Nadu, they have successfully launched a mini satellite named Vicosat 1. What is it about? 1600 grams mini satellite, high altitude, using a balloon payload, not an orbital satellite. Objective is to detect fungal spores in the stratosphere. Okay, so method launched by a helium balloon to 22 km altitude. Basically, it is significance fungal spore influence agriculture, health and ecological cycles. It will provide real-time high altitude atmospheric data difficult through ground-based monitoring. So with this they can promote the agriculture health in India. Okay, this also shows the innovation in Indian science community. Right. So regional navigation satellite was asked by UPSC previously. On the same lines, we have a question based on Vikrosat 1, recently seen in the news. It's a small satellite developed under India's expanding private space ecosystem. Right, this is a correct. It reflects the growing role of private participation in India's space sector. It is designed primarily for strategic nuclear testing and defense applications. This is an incorrect statement. This is for the agriculture, health and ecological cycles. Right. The last major theme for today is the culture. Let's see one by one. Thai Pusam. The Prime Minister recently greeted everyone on the occasion of Thai Pusam. What is this all about? This is basically a Hindu festival celebrated to honor Lord Murugan, also known as Lord Kartikeyan, the Hindu god of war, victory and wisdom. Right. The Thai Pusam is a combination of two words, Thai, the Tamil month, and the Pusam is the name of a star which is at its highest point on that day. Right. During this festival, it is celebrated on the full moon in the month of Thai. Okay, this festival is marked the day when goddess Parvati presented a Lord Murugan with a divine spear known as the well, with which the Murugan defeated the Surapadam. This event symbolizes the victory of good over evil. It is widely celebrated in the Tamil community in Tamil Nadu and also across the world, for example, especially in Sri Lanka, Singapore and Malaysia. Right. With reference to the Thai Pusam festival, consider the following statements. It is associated with the worship of Lord Murugan, correct. It predominantly celebrated by the Tamil communities, correct. It marks the victory of Lord Shiva over the demon Suprapadam. This is incorrect. It was Lord Murugan or Lord Kartikeya, not Shiva. So answer would be 1 and 2 only. Next we have is an Devanimori relics. The holy Devanimori relics of Lord Buddha arrived in Sri Lanka for an exposition. This shows your cultural connect. Also promote your soft power diplomacy. Okay, so it marks a moment of profound spiritual, cultural and civilization significance, strengthening the bond between India and Sri Lanka rooted in their shared Buddhist heritage. Devanimori archaeological site, please remember it is in Gujarat. Okay, the site is in Gujarat, which is a Hindu pilgrimage center of Sarmalaji in Gujarat's Aravali district. The site was first explored by the archaeologist S.N. Chowdhury. So these are some factual information you have to prepare. The relics casket discovered within the Devanimori stupa bears an inscription in Brahmi script and Sanskrit reading Dasabhala Shrira Nilay. That means the abode of the Buddha's bodily relic. Alright, so this time it is in Sri Lanka. Devanimori recently seen in the news associated with, it is a Buddhist relic discovered in Gujarat. So please remember, this time these relics of Buddhas arrived in Sri Lanka, but it is basically from Gujarat. Okay, so please understand this difference. Bastar Pandum festival. Bastar is in Chhattisgarh. It is a state festival, a tribal festival held in Bastar region to promote Bastar tribal identity through art, music, dance, handicrafts and indigenous cuisines. It is to promote, preserve the indigenous tradition, empowerment of local artists and communities, transmission of cultural knowledge to younger generation, promotion of cultural tourism and local livelihood. So consider the following statements regarding Bastar Pandum festivals. It is a tribal cultural festival celebrated in Chhattisgarh. Okay, this is correct statement. It promotes preservation of indigenous traditional art forms. This is correct statement. It is organized exclusively by the Ministry of Culture. This is an incorrect statement. Answer would be 1 and 2 only. Right. Now, C. Rajagopalachari, very important. Recently, President Draupadi Murmu unveiled a statue of C. Rajagopalachari in the central courtyard of the Rashtrapati Bhavan, replacing the old bust of Edwin Lutyens. Now, about the C. Rajagopalachari, he was born in 1878 in Tamil Nadu, which was part of the Madras presidency that time. He was an Indian statesman, writer, lawyer and Indian independence activist. For this, he is also known as C.R. and Raja Ji. Okay. In 1911, he was elected to the Salem Municipal Council. Later in 1916, he joined Annie Besant's Home Rule League movement. He also elected in 1970 as the chairman of the Salem Municipal Council. He also supported the Rowlatt Satyagraha. Okay, and he was very much active in the non-cooperation movement. gathered momentum in the Tamil Nadu under his leadership. Right, he gave up his legal practices in the support of non-cooperation movement and also promoting boycotting elections, educational institutions, government posts and official titles. He also led the salt satyagraha at the Tanjavur coast, very important. Rajaji formula, 1944, he proposed a formula where Muslim League and Indian National Congress can come together to have the power transfer from the Britishers. This formula was about the plan required All India Muslim League to support Indian National Congress in forming a provisional national government, which is provided INC agreed to abide by the plebiscite on the question of Pakistan. Right, the plebiscite was to be held after the transfer of power from Britain in contiguous Muslim majority districts in northwest and east of India. However, this was not accepted and it was not implemented as well. When it comes to social reforms, CR was also a leading supporter of temple entry movement for the marginalized sections. He advocated Dalit upliftment, and in 1938, as a premier of Madras, he supported the legislation that made a discrimination in employment, access to wealth, health, public as a punishable offence. Okay, post-independence, very interesting fact, he succeeded Lord Mountbatten as the Governor General of India. Okay, so he was the first and only Indian who have the post of Governor General. Okay, that was also there. Later on, he served as the Home Minister and later on he served as the Chief Minister of Madras, respected by both Gandhi and Pandit Nehru, who called him his conscience keeper. Rajaji was awarded as the Bharat Ratna in 1954. He was awarded as a Bharat Ratna as well. Right. Swatantrata Party, but by the mid 1950s, he has some sort of difference of opinion with the Indian National Congress and he established his own Swatantrata Party, okay, which came from the Forum of Free Enterprise, which promoted the All India Agriculture Federation as well, right? So that means Rajaji was associated with INC, yes, Swatantrata Party, yes, Forum for Free Enterprises, yes, and lastly, it is All India Agriculturalist Federation. Okay, so he was associated with all these, right? He promoted free enterprise while rejecting the 19th century laissez-faire capitalism. Okay, when it comes to literary contribution of C. Rajagopalachari, right? His most popular works include retelling of the Ramayana and Mahabharata. He received Sahitya Akademi Award as well. Okay, Sahitya Akademi Award for Tamil retelling of Ramayana known as Chakravarti Thiru Magan. Okay, this is Tamil Ramayana. Please remember these facts for a prelims examination. Let's have a prelims MCQ for this. With reference to the C. Rajagopalachari, consider the following statements. He was the last Governor General of the independent India. So yes, he was the first Indian Governor General and also the last Governor General of India. After that, India became the Republic. Okay. So he founded the Swatantrata Party. Yes, he served as the first President of India. This is an incorrect statement. He was Rajendra Prasad, who was elected as the first President of India. Now, let's have a mains PYQ. Now, UPSC has a mains PYQ. To what extent the role of moderate prepare a base for the wider freedom movement? Comment. Here you can also mention the efforts of C. Rajagopalachari, Rajaji, in non-cooperation movement. Okay, we have seen during the Rowlatt Satyagraha and also during the Salt Satyagraha. Okay, and later on also you can mention his contribution with the base for the wider freedom movement. Okay. Now, mains, if I come, evaluate the contributions of C. Rajagopalachari to India's political and intellectual life. The political life, first of all, you have to mention his contribution with respect to the INC and Gandhian movement. For example, you have this non-cooperation movement, Rowlatt. Before that, you have the Rowlatt Satyagraha. Then you have the Salt Satyagraha at Tanjavur coast under his leadership. Later on, he formed this Swatantrata Party because they're asking the political and intellectual life. They are not limited to the till the independence. After that, Swatantrata Party, Federation of All India Agriculturalists. Okay, and then intellectual life may you have to mention his views on Ramayana and also that led him to the Sahitya Akademi Award. Right. So this is all about you have to write in this answer. Now, C. Rajagopalachari, contributions to India's political and intellectual life, early life and freedom struggle, key political initiatives, social reforms, and also post-independence leadership. So you have to mention each and everything to answer this question, right? So we have this O.I. Chiki script. Ministry of Culture has organized the centenary celebrations of this script. On the occasion, the government has released a commemorative coins and commemorative postage stamps, right? This is O.I. Chiki is the official script of the Santhali language, very, very important. One of the India's prominent tribal languages spoken widely where Jharkhand, Odisha, West Bengal, Assam and Bihar. Please remember, the Santhali language belongs to the Austro-Asiatic language family, right, which is very, very important. Then you have to important that this O.I. Chiki script was developed in 1925 by Pandit Raghunath Murmu, and he also authored High Serena, the first book in O.I. Chiki script. Right, a defining moment as the journey of O.I. Chiki script came in 2003 when the Santhali language was formally included in the 8th schedule of the Constitution of India. Please remember that Santhali is one of the scheduled languages in 8th schedule of India. Right, so based on that, script question was asked by UPSC. Now we have the prelims question. O.I. Chiki script is associated with which of the following? So it is the Santhali languages. With this, we comes to the end of our discussion. Thank you for joining. Goodbye. Take care.